Okay, hello everybody. Hello. Welcome, welcome. Oh, my day's been just fine. So far, so good. Welcome. Hello. Yes. Yes. Happy Friday, everybody. It's good that we all made it. Hello. Hello, everybody. Hi. Welcome. Welcome back. Hello. Yes, let me get everything in frame here. I just got back from the movies, so I'm just putting everything together. Yes. Hi, welcome. I had one of the first firms I worked in, the criminal defense attorney, always went to a Friday matinee. And so I tried to keep that tradition as I went on with my career. Oh, I went to see, Aloha. I went to see Barbie, actually. So you'll have to excuse my pink nails. But yeah, it was fun. Yeah, it was fun. Highly recommend. Very fun. It's not necessarily a deep thoughts movie, but sometimes you don't need a deep thoughts movie. So yeah, it was pretty fun. But the attorney that I worked for, his name was Roger, and he always went on Friday afternoons whenever he wasn't in trial. He would go to a matinee. And he said that was a really good way to just kind of decompress after a long week. So I definitely would agree with that. So, all right, let me make sure I have all my documents in the right order. Oh, The Sound of Freedom. Okay. Yes. Oh, well, thank you. Yeah, I've got my Barbie nails. Hopefully that'll still be okay. Even if I have my Barbie nails, I can still show you everything. So let me get a little closer to the mic here. We had a hearing a few hours ago in DC. So, let's see. I have not read the order, so we'll be reading it together, which will be fun. But for anyone who is interested, it shouldn't take too much time to go through the order, but I think it's kind of worth it after this. The last about 10 days have been pretty busy. So hopefully, I think there are a few really good points that the judges made in the order. It looked like she kind of knocked back the government a little bit, but she also kind of kept everybody in line. So love to see that. Absolutely love to see that. Oh, yes, absolutely. No, I'm happy to answer questions, Serena. I'm so glad people are interested. I thought it was just me. So it's nice to be able to share the information with other people as well. So happy to do that. Yes. Oh, okay. Well, congratulations for graduating. That is definitely a huge achievement. Oh, thank you. This one I think is a Pentel. You know, I'm all about how it writes. If it has a good, easy way of writing, I'm all about that. My day's been pretty good. I typically try to take Friday afternoons off and go see a movie. I started doing that in law school when I started working at a law firm. So I've kind of kept that tradition going as time has gone on. So I find it to be very helpful to just relax and go into the weekend saying, it's going to be okay. Am I single? No, I'm not. I'm married. Very married. Yes. We had a red, white, and blue wedding. Yes. All of this information is public. This is the public docket here. But it's all public, and the orders that I will be going through here in just a few minutes is the order the judge issued this afternoon. So it's all public. What was the last movie? I just got back. I went to the Barbie movie. So that's why I've got Barbie nails today. I'll try to put them to the side a little bit, but yes. Well, hello again. Yes. Welcome, welcome. Yes, 14th Amendment, Article 3. Very, very interesting conversations going on about that. Very interesting. I thought it was pretty good. Of course, it was pretty campy in some places, but I think that was expected. Attorney Barbie, oh my goodness. Oh, I found it to be entertaining. Sometimes I think you just need to escape reality for a little while, so it definitely helped with that. Sometimes it's good to go and have a thinking movie, but sometimes it's okay to just go for fun. So that was really my goal today, was for fun. Yeah. Oh, Elwood's. Yes, of course, of course. Absolutely. Well, we are Americans. True. Oh, hi, Ken. Yeah, it was pretty fun. Oh, it was a great movie. It absolutely was. Oh, thank you. Thank you. Oh, goodness. Well, let's go ahead and get started. I won't be taking too much time up tonight. I know I say that every time, but I really mean it this time. But oh yes, got to have a little bit of junk food. It's a once in a while food for sure. But so we've got, this is the docket, and I pulled it for today to kind of update everybody about where we were. So, of course, we have the indictment here listed as August 1st. And I've gone through all of these documents in other lives previously. Other times I've been on TikTok Live, not like previous lives, but you know what I mean. And taken all the way up until... let me see. I pulled the last document, which was document 19. I think it was 17. Was it 17? Yeah, it was 17. So this is kind of where we left off, was with document 17. And again, if you go and look for the docket online, all of this is, of course, public information, and you can pull up the docket, and it will set out on one side the number that the document is, which is always listed at the top. So, this is document 17, so I know that this one's document 17, the date it was filed, and then kind of a brief summary of what it was. Now, some of the orders don't have a full written order, so it's kind of just a summarization that's put into the docket, which is fine too. So that can kind of happen as well. But so I think the last time I had gone up to document 16. So I'll start today with document 17 and just kind of take us through, because we've got 17, 18, 19 that came down. 20, which was here, which was just a notice. And again, this is an example of an order that was just kind of set in here, but pro hoc vice order, but it doesn't have a printed order that went with it. Then we also have a notice here, a motion for leave to appear pro hoc vice, which again is something that's kind of unique to cases where there's a lot of interest in knowing what's going on. We've got a memo in opposition by the government, and then we've got a notice of attorney appearance here, Todd Blanche, and that's document 27. We have now we kind of get things a little bit messed up here, because we've got 26 and 27, but then now we're at 23, which was technically filed up here. This is a response to the order. Now there is no 24. Document 24 is not listed, which is absolutely normal. Nothing strange about that. That just sometimes happens. Oh, should I stop so I don't look like a fool? Oh, I'm happy to look like a fool. Never had any problem with that after 3 years of law school. No problem with that whatsoever. But we don't have a document 24. Again, no worries. That's normal. And then 25, we have a motion for a hearing pursuant to the Classified Information Procedures Act. So that's SIPA hearing, because some of the information involved in the case is confidential. So, which is, again, perfectly normal. So what the newest pieces have been, we've got August 10th, this minute order, which set this out. And then we had a motion and a hearing. And so what I want to go through are the order that was set out today when she went through and talked about the protective order. She did issue a protective order that has kind of a blend of what the government was requesting, but also added a bit to what the defendant was asking for as well. So not 100% of either one of their requests, but kind of a blend, a mix of them, which I thought she did an excellent job. So with that, so I'll go through that and just kind of explain the language involved. And she did set the next hearing, so we do have that. Can we see the ring? Oh, sure. Oh, yeah, this is my big sparkly, my big sparkly ring. I never know. I just kind of grab whichever one is the shiniest for the day. So yeah, my mods should be here anytime. So we should be okay. Other than that, I would just ask everyone to just be kind. I'm extremely careful about the community guidelines, so I would appreciate it if everyone was respectful about that. I'd be very thankful. So I don't want to need to block anybody, but I will if I need to. Jennifer, yeah, corrupt activist judge, right. So then my question is to everyone, if you don't like the judge, who do you think the judge should be? And then why do you get to pick the judge instead of the people that normally pick the judge? That's usually my question that I ask, because that's really something to think about. All right, let's go ahead and dive in. Let me go through the documents here. I won't take too much time on them, but I do want to kind of explain what they are. Starting with document 17. That's really where we left off the last time I went through. Democrats do not respect the law or the truth. Well, I think there's people, they'll pick a biased judge. Well, this one was kind of like a spin the wheel situation, so it was completely random. Only Oprah can judge me. I feel the same way sometimes, Larry. I think that's appropriate sometimes. I think she would do a good job. Yes, the judge was picked at random. This judge was, as well as the one in Florida. That's how all of our judges are picked. They just kind of have a way that they spin the wheel, so to speak. Well, and I can understand any federal judge that's not in D.C. Well, I get it. But then again, my question is, how come you get to pick the judge instead of following procedures? Hello, CJ. Welcome. Oh, hello, Raymond. Welcome. Thank you for coming. I appreciate that. Right. Judges should not be affiliated with any particular party unless, of course, they have to go in and run elections. So sometimes that happens depending on which jurisdiction you're in. I'm not a huge fan of that particular way of choosing judges, but it can happen. All right, so let me start diving in. We'll go in here with document 17, which was filed on the 8th. This is a joint notice in response to the court's August 7th minute order. Now, if everyone remembers, we had the government that put in a request for a protective order. We had a response to that. We had a reply to the response. And we kind of went back and forth, and then the judge said, you guys need to sit down and pick out some dates here. So that's what this is. This is a joint notice. So both sets of attorneys then have put this one forward by minute order on August 7th, and that again just means it's in the docket, but it's not a big, huge order that you can just print out and look at. The court directed the parties to meet and confer and inform the court by joint notice, quote, of 2 dates and times on or before August 11th, when both parties are available for hearing, end quote. The parties have conferred and hereby provide notice. The government is available anytime on August 9th, 10th, or 11th. Defense represents the following. And so you'll see here, the government's like, okay, these are the dates I'm available. And then the defense has this following response. And I think this there's absolutely nothing wrong with it. It's absolutely fine, but it goes to show you how different lawyers have different styles of responding. So, which I'm always fascinated by. Again, absolutely nothing wrong with that, just different styles. President Trump will not appear. However, he would like to have both his counsel, John and Todd, at the hearing. Todd is not available on Thursday since he must appear for a court proceeding in the prosecution brought against the same defendant, President Trump, by the special counsel in the Southern District of Florida. Mr. Lauro is available on Thursday with a preference for an afternoon setting. However, since we lost Friday as an option, we would respectfully request a setting on Monday or Tuesday to allow for both Mr. Blanche and Mr. Lauro to be present. So this was his request for the dates, and this was the government's request. So again, I'm just going one document at a time to catch everybody up on what the documents are saying here. So now we move into the next document, which is document 18, which was also filed the same date. And this is a motion for exclusion of time under the Speedy Trial Act, which again is very typical. This can be added in where necessary, depending on the facts and circumstances of the case. So in my highlighting colors, I have the defendant here in orange and the government's in green. The court is in pink, in case you were wondering. So this is a motion from the defendant. That's why it's in orange. President Donald J. Trump respectfully moves to exclude the 25 days between August 3rd, which was the initial appearance, and August 28th, the first status conference, from the Speedy Trial Act calculation pursuant to this section of the code and applicable case law. This exclusion is warranted by the complexity of this matter, including the substantial volume of discovery, and there really is a lot of discovery, like a lot. I have never seen in a criminal case this much discovery when you're talking about just sheer documents. So there really is a lot. And novel questions of fact and law. Now that part I'm not so sure about, but it definitely has a lot of discovery. President Trump is charged in a 4-count indictment, wrongfully alleging conspiracies spanning months and involving hundreds of potential witnesses across the country. Prosecution states this case will involve a substantial amount of discovery, which is very true. Additionally, this matter raises significant constitutional issues. Now that I'm not sure about, but I think it's a good defense to go forward with those kinds of questions if you're representing the defendant. And other novel questions of law and fact. We anticipate, among other things, reviewing terabytes of electronic information and hundreds of thousands of pages of hard copy documents, filing numerous critical motions, interviewing hundreds of witnesses, issuing dozens of Rule 17 subpoenas, retaining expert witnesses, etc. Under this section of the code, a court can exclude periods of delay from the 70-day period within which a criminal trial must commence. Under this section of the code, it sets forth certain factors that the court must consider. Among those is whether the case is so unusual or so complex due to the nature of the prosecution or the existence of novel questions of fact or law that it is unreasonable to expect adequate preparation for pretrial proceedings for the trial itself within the time limits established by this section. And that's an end of quote. As well, I think my mods should be in here by now. So hello, mods. Hopefully you're here. I know a lot of people have been dinged recently on their lives, and so I'm just very careful just to make sure that everyone is being... Oh, thank you. Yay, Mads. Woohoo. Okay, excellent. Thank you kindly. Thank you very much. I will put it all within your purview and trust you to take care of that. Thank you kindly. Yes. Thank you. All right, let's move on then. Here, the sheer number of witnesses and volume of discovery alone warrants a continuance, to say nothing about the issues of first impression that the parties will inevitably have to brief. All right, fair enough. Approving continuance due to the lengthy time needed for discovery and its impact on defense counsel's ability to prepare for trial. For a case of this magnitude, it will be impossible for the defense to evaluate the government's evidence, prepare its own defense, and participate in pretrial proceedings, all within the time constraints of the Speedy Trial Act. That's a good point. Accordingly, the ends of justice would be severed by the exclusion... What's that? By the exclusion of the 25-day period from the Speedy Trial Act calculation. Okay, the prosecution requested that we include the following statement in our motion. Wow, that's pretty blatant. They don't seem very happy about that. So let's see what they say. The government's position is that the ends of justice are best served by a speedy trial. Ooh, burn. And they had them put it in their own motion. Ooh, that's harsh. And the government will respond more specifically once it's had the opportunity to review the defendant's motion. I feel like this is really going to be quite the battle back and forth between these attorneys for sure. But if both parties, well, I'm not sure about that. Can't be used by the government. That's correct. That's correct. Although they do have an interest in serving justice. So, I mean, they can make their points known, but of course that speedy trial element is something that is a safeguard for defendants. That's the intent of it anyway. So this is document 18. Again, I'm just taking you through until we get to the order today. Just a few documents here, not too much. Document 19 and document 20. So we have, these really go together. We have a notice of filing certificate of good standing in support of a motion for admission pro hoc vice. So we have Todd Blanche, Esquire, who is wanting to be pulled in pro hoc vice, which just means they want to be an attorney of record, but it looks like he's coming in as part of this team here, but respectfully submits his certificate of good standing dated August 8th. This certificate is to replace the copy that was dated and accompanied the motion. This is what I was talking about there was a motion that was misfiled, which happens all the time. Very, very typical. So he refiled this motion and then added onto it this document here. So this is part of that misfiled motion. So he put it on into the proper format with document 20. So this goes in and just says that he is licensed, admitted to practice as an attorney in all of the states of the state as of this date, was duly taken, subscribed by oath, and so on. So this is just a certificate that he's in good standing with the court for his pro hoc vice motion. How long before it's enough? Before how much is what's enough? You have to be more specific about that because there's a lot. There's a lot of enoughs. Is he on any type like restrictions? Can't do this? I don't think so. Yes, it is very fancy. Yes, they can ask for more time. Absolutely. Absolutely. And okay, I get you. Speedy trial will vary depending on your jurisdiction. So here they're saying it's 70 days, but sometimes we've got 90 days. And especially with COVID, there have been some exceptions made to those different kind of deadlines also. So, oh, sure. All right. So next we've got document 21 here, which is, again, notified that this person's appearing for the defendant that's indicated above in the entitled action. So again, this is just notice that we're putting on another attorney in here. Okay, so from this law firm, and there's the bar number. And that's document 21 that was filed. Now document 22 is a motion for admission pro hoc vice. Again, perfectly normal. Although I guess it's a little bit unusual. So to have so much pro hoc vice, I suppose. But maybe, I mean, I don't spend a lot of time in federal court, so maybe this is pretty typical. But, yeah. Yep. So, pursuant to local criminal rule here, Mr. Singer respectfully moves to appear pro hoc vice and participate as counsel for President Donald Trump in this matter. So we've got another counsel coming in. This motion is supported by Mr. Singer's declaration and Florida's certificate of good standing. As set forth in the declaration, Mr. Singer is an active member in good standing of the bars of Florida and the United States District Court for the Northern, Middle, and Southern Districts of Florida. This motion is supported by Mr. Lauro, Esquire, an active member of the bar of this court, and Mr. Singer's sponsor, Mr. Lauro's signature is below. So, again, more technical information coming in, just saying I'm a member of the bar. I've not had any disciplinary action towards me. We've not had any recent pro hoc vice because you're only allowed to apply as pro hoc vice a certain number of times. So, pretty normal. Again, and then we've got some more, another example of, being in good standing. Are you a member of the jury? Oh my goodness. All right, so that takes us then, that was document 22. That takes us then to 23. Now we're getting into the government's first filing. after the last batch that we had looked at. So the government's response to the court's August 3rd minute order. So let's go through that. This isn't actually very long. It looks like it is, but it's actually not. So government's response here. In its August 3rd minute order, the court directed the government to file a brief proposing a trial date and providing an estimate of the time required to set forth the prosecution's case in chief. Again, the prosecution has the burden of proof, and so they're the ones presenting the case. The defendant does not have to present a case. He is innocent until proven guilty, so at trial. The government proposes the trial begin January 2nd and estimates that its case in chief will take no longer than 4 to 6 weeks. That's, that seems like a decent estimation. This trial date in the proposed schedule outlined below would give the defendant time to review the discovery in this case and prepare a defense, and would allow the court and parties to fully litigate any pretrial legal issues. Most importantly, on January 2nd, a January 2nd trial date would vindicate the public's strong interest in a speedy trial, an interest guaranteed by the Constitution and federal law in all cases, but of particular significance here, where the defendant, a former president, is charged with conspiring to overturn the legitimate results of the 2020 presidential election, obstruct the certification of the election results, and discount citizens' legitimate votes. Government's proposed trial date and schedule. So then they're going to list out what they think would fit best for them into their schedule. The estimate to estimate a prompt trial date that serves the public's interest and the interest of justice, while also protecting the defendant's rights and ability to prepare for trial, the government outlines below suggested interim dates subject to the court's schedule and availability. So now we really get into the details of what kind of a schedule the government is looking at. So this will give us a lot of insight into which directions they're thinking about going in, how long they think it's going to last. We've got Rule 12, other dispositive motions, which is normal, oppositions, replies and supports here, motions hearings to be determined, motions in limine, oppositions to motions in limine, replies, pretrial conference, and jury selection. Now, this is interesting because they're looking at jury selection and they're saying the trial could begin January 2nd, so they're estimating just a couple weeks, maybe 2-3 weeks for jury selection. So these, they would know their case best in order to give a good, proper estimation. Yes, and it's all online as well, too. So up to you. Hopefully I'm in frame well enough. You'll have to make sure and let me know. This general schedule would give the defense almost 2 months after indictment to file Rule 12 and other dispositive motions, which raise legal issues. Now, let me just make sure. Let me grab my book so that everybody knows what a Rule 12 motion is. So we have different motions that have to be filed by certain periods of time, depending on the content of the motion. And so what they're referring to here are affirmative motions in the Rule 12. So we have pleadings, motions, pretrial motions, any of those that can be raised by the defense, any objections, and so on. So just all these other improper venue, violation of constitutional rights, all of these different motions. That's what he's talking about when he's saying the Rule 12 motions, just to clarify for everybody. All right, so to file Rule 12 and other dispositive motions, which raise legal issues, not issues of fact, stemming from review of discovery. And then we will bump down here into our footnote. It appears that defense counsel is already planning. Let's see here. It appears that defense counsel is already planning which motions the defendant will file. For instance, on CBS's Face the Nation on August 6th, Mr. Lauro stated, quote, "We're going to be identifying and litigating a number of motions that we're going to file on the First Amendment grounds." Oh my goodness. Or the fact that President Trump is immune as president from being prosecuted in this way. He also expressed an intention to pursue a change of venue. And then he cited where that comment was made. So that's interesting. He included that in his motion, the government did. So we've got Yeah, a lot of that information. I mean, it's, who, of course, you're not under oath. If you're like, oh, we're going to file all these motions, it doesn't mean you have to. But I think it's interesting that the government is citing a television appearance here. So, yes, it is, Bertie. You are correct. It would then provide roughly 5 months before the start of the trial for the defense to review discovery, which, as described below, the government expects to be substantially complete in advance of the court's hearing on August 28th. This schedule also proposes that the court set a date certain to start trial January of 2024, regardless of when jury selection finishes in December of 2023, to avoid uncertainty and hardships for jurors during the winter holidays, which is true. We always take that into consideration on the timing on that. The government's proposed trial date vindicates the public's interest in speedy trial while protecting the defendant's rights and the need to prepare for a defense. On January 2nd of 2024, the trial date represents an appropriately speedy trial in the public interest and in the interests of justice, while affording the defendant time to prepare his defense and raise pre-trial legal issues with the court. The government has undertaken extensive efforts to prepare and organize discovery in a manner that will assist the defendant in his review of produced materials. Now, I think that's nice, and that's, thankful, but of course defense is going to want to look at those materials in their own way. So although that's helpful, that's not necessarily a selling point. Assuming that a protective order is entered, the government expects to have substantially completed discovery in this case by the next hearing on August 28th. This court, like federal courts throughout the nation, can and will ensure that the defendant receives both a fair and speedy trial. The Constitution and federal law provide that a speedy trial is in the public's interest and in the interests of justice. At the defendant's initial appearance and in several television interviews, defense counsel has suggested that the Speedy Trial Act is intended only to protect the defendant's rights. Of course, Speedy Trial Act protects the defendant's rights, and we're quoting Fox News here. Speedy trial rights are a defendant's speedy trial rights, a citizen's speedy trial rights, not the government. So, I'm just waiting for everyone. Am I lagging just a little bit here? Oh, I'm good. Okay, just making sure. I just wanted to make sure. I'm checking all of my different... Okay, good. Thank you so much for telling me. I'm checking all my different points here. Okay, not so. Under both the Sixth Amendment Speedy Trial Clause and the Speedy Trial Act, the right to a timely trial is vested in the public, not just the defendant. Okay, the right to a speedy trial is generically different from any other right enshrined in the Constitution for the protection of the accused, since there is a societal interest in providing a speedy trial, which exists separate from and at times in opposition to the interests of the accused. Well, that's an interesting legal argument. Okay. The Speedy Trial Act was designed not just to benefit defendants, but also to serve the public interest by, among other things, reducing defendants' opportunity to commit crime while on a pretrial release and preventing extended pretrial delay from impairing the deterrent effect of punishment. That's an interesting argument. The public has great an interest in prompt criminal trial, as has the defendant. Certainly the public is the loser when the criminal trial is not prosecuted expeditiously, as suggested by the aphorism, justice delayed is justice denied. I think it's a good try. I'm not sure it's going to be a successful argument, but it's a fair try to present. So consistent with the Speedy Trial Act, let me just double check. Am I in frame okay here? I've got some of my, okay. Oh, good. Yeah, oh, excellent. All right, so consistent with the Speedy Trial Act, the D.C. Circuit has accorded significant weight to the public's interests, observing that in applying the Speedy Trial Act, district courts must seriously weigh the strong public and private interests served by speedy trials. Again, I think that's a It's a fair argument. I'm not sure it's a winning argument, but, I think it's good to propose and try to go forward. It is difficult to imagine a public interest stronger than the one in this case. So I think they're presenting this as this is kind of a novel situation, and we need to take that into consideration, in which the defendant, the former president of the United States, is charged with 3 criminal conspiracies intended to undermine the federal government, obstruct the certification of the 2020 presidential election. Hold on here, please, just one moment. I'm having a technical difficulty moment here, so let me get sorted back out again. Okay, here we go. All right, so the former president of the United States charged with 3 criminal conspiracies intended to undermine the federal government, obstruct the certification of the 2020 presidential election, and disenfranchise voters. That is true. That's a valid point. Very good point that he has there that he's making. I think that's good. Again, is it a winning point? I don't know, but it's a good, valid point. The D.C. Circuit has determined that there is direct linkage between the defendant and the events of January 6th of 2021, which is described as the single most deadly attack on the Capitol by domestic forces in the history of the United States. Okay, fair enough. That really escalates everything. Trial in this case is clearly a matter of public importance, which merits in favor of prompt resolution. So, and that may be a good argument. But again, I think the government is asking the court to recognize the Speedy Trial Act a bit further than it has before. So, anytime you're asking the judge to do that, you can win sometimes, but not necessarily on that. So we'll see. Water break. Thank you. Thank you for the reminder. Got all kinds of weird technical things going on here in my corner I had to take care of, but I think we're good. The government is prepared to exceed its discovery obligations and provide substantial assistance to aid the defendant's review of produced materials. During the initial appearance hearing on August 3rd, defense counsel argued that a principal reason for delaying trial in this matter is the defendant's need to review discovery. It is perplexing then that the defendant has refused to accept the discovery that the government has ready, even on an interim basis, under the government's proposed protective order, while the parties litigate the ultimate protective order in this case. That's interesting. In any event, although there's a large amount of discovery, there really is a lot of discovery. Let's just take a moment and acknowledge that. It's a huge amount of discovery, including witnesses, interviews, grand jury transcripts, and evidence obtained through numerous sealed search warrants. The government has gone to great lengths to organize the materials for the defendant to assist him in his review. And again, I would pause and say, if I'm defense counsel, I'm thankful for the prosecutor taking the time to organize things, but I'm still going to want to, take a look at it and organize it myself. These efforts include providing him a compilation of certain key evidence on which the indictment relies, and identifying material potentially favorable to the defense, which is good. That is important to do and helpful. Indeed, assuming that a protective order is entered in the interim, by the time the court's hearing on August 28th, the government expects that its production of discoverable materials already in the government's possession will be substantially complete. The government would then continue to produce the defense on a prompt rolling basis, any additional materials that are obtained going forward. And then that bumps us down here. In a separate filing today, the government's requesting that the court schedule a pretrial hearing under the Classified Information Procedure Act, so CIPA, so that the parties can discuss a parallel schedule with respect to the minimal amount of classified information that may be subject to discovery in this case. Yeah, I was going to say I didn't think we had much for classified documents. Well, they really don't control what the defendant can see. They have to give everything over. All of it has to be given over, or there could be violations. Right. The government's prepared at this moment to produce to the defendant the majority of discovery in this case, including materials that exceed its obligations. As soon as the court issues a protective order, the government will produce to the defendant materials including grand jury transcripts and associated exhibits through the date of the indictment, witness interview recordings, transcripts, and reports, including agent notes, along with records used during the interviews. The vast majority of materials obtained through search warrants, so 2703D orders and grand jury subpoenas, and unredacted materials obtained from other government entities, including the House Select Committee to investigate the January 6th attack on the United States Capitol and the United States Secret Service. The government went to great lengths to organize these materials in a user-friendly manner. And again, I would pause and I would say thank you, but again, we're going to kind of want to take a look at that material yourself if you're the defendant. But I think that that's nice, saying, hey, we're trying to work with everyone that's involved and set things out in a way that's easy to manage. So it's like, thank you, but that's interesting. We're not going to necessarily rely completely on their way of organizing it, but I just putting that out there from a perspective from the defense side. Oh yes, there were definitely committee materials involved. Prepare them in formats ready to be loaded into a document review platform. And that's, again, helpful, but, it's up to the defense to pick which platform they want to use, and create detailed logs to guide the defendant's review. And then that bumps down. The government will move separately to provide the court ex parte, which means only one-sided, just meaning they will themselves give this information to the court. They don't need to call a hearing in. And under seal, a draft copy of the detailed production letter and source logs that the government intends to provide to the defense upon the entry of a protective order. These materials demonstrate the scope of the government's disclosures and the steps taken to organize the discovery material so that it's readily accessible for the review and use of the defense. Again, that's helpful, but I'm not sure that's really a selling point to the judge, would be my guess. The government will also provide a compilation of certain... The government's being very generous, or maybe that's just how they had to organize it themselves. I don't know. I don't know. They're certainly putting themselves out as being very generous. Key evidence that supports the charges in the indictment in itself, a detailed 45-page speaking indictment that provides a roadmap to the government's theories, and identifies certain material within the discovery that is arguably favorable to the defendant. I think that is arguable. The government stands ready to provide technical assistance or answer any questions the defense counsel may have regarding the discovery in this case, which is what they're supposed to do. Defense counsel claimed both in the media interview and at the initial hearing. Let's bump down and see what this is. National Public Radio. Trump's attorney tells NPR how he plans to defend against the latest charge. Interesting. That the government has been investigating this matter for 3.5 years, while the defense is starting with a blank slate. Not only is this claim impossible, as January 6th, 2021 was 2.5 years ago, but it's disingenuous. So I think there's a little... They're trying to slip a little bit of a knock in on that. They're like, oh, it's only 2.5 years. Oh my goodness. The defendant has been aware of and has responded forcefully in opposition to certain relevant information made public through hearings and the report written by the House Select Committee to investigate the January 6th attack on the United States Capitol. See the letter from Donald Trump. So he's citing a particular letter here. Furthermore, the defendant and his counsel have long been aware of the details of the government's investigation leading to his indictment, having had first contact with the government counsel in June of 2022. Indeed, at his initial appearance, the defendant was accompanied by an attorney familiar with certain relevant pre-indictment information. In sum, the defendant has a greater and more detailed understanding of the evidence supporting the charges against him at the outset of this criminal case than most defendants. I think that's probably pretty fair to say. But we are dealing with a bit of a unique situation. Do you know how many attorneys are on the government's team? I don't know. I think, they've got to have at least, I'm wondering if there are 3 or 4 sitting at the table and then all of the assistants that come in as well. Yes, there's probable cause. That's it. There's not proof beyond a reasonable doubt by any means. Nope, we are at probable cause. Absolutely. it's going to be a very interesting case. I mean, they're already kind of sparring back and forth. So even just going through their motions, it's interesting to see how they're kind of throwing some lobs at each other, I think. Yes, that's an excellent point. Are you an editor? I'm wondering. This must be driving you completely bonkers if you're an editor. Oh. Okay, so yes, this is probably a true statement, and is ably advised by multiple attorneys, including some who have represented him in this matter for the last year. The government's proposed schedule and January 2nd trial date afford the defendant many months to review the discovery on this matter, raise pretrial legal issues, and prepare his defense. No additional time is necessary or warranted under the Speedy Trial Act and in light of the public's strong interest in a prompt trial. And again, I think that's a good argument to make. I'm not sure that it's necessarily going to be persuasive. Federal courts throughout the nation have navigated substantial cases while ensuring speedy trials. That's true. The proposed schedule provides ample time for the court to ensure that the defendant receives both a fair and speedy trial, just as other courts throughout the country have in cases of substantial size and complexity. Other courts, for instance, have successfully administered justice in an efficient and just manner in complex cases. And then he's citing a few cases here. Paul Manafort, Muhammad, Robert McDonald. So they're citing different examples of that. In addition, over the past 2 years, courts in this district have fairly and efficiently managed the largest set of related criminal cases in American history. Ooh, that's a really good point. That's a very good point, actually. Their district has been very busy over the last year or so. Involving more than 1,000 individual defendants charged with crimes associated with the breach of the United States Capitol on January 6th. The fair and efficient administration of the defendant's single criminal case pales in comparison to that challenge. Okay. So, and then they'll put their prayer at the end. The government proposed trial date represents an appropriate balance of the defendant's right to prepare a defense and the public's strong interest in a speedy trial in this case. The government respectfully requests that the court set a trial to begin January 2nd. So we will see what happens. Ooh, Lady Unicorn Farmer. That's fair. I mean, everyone's entitled to their own opinion. No, it's okay. That's fine. So that was, I'm actually reading the document. That's also a good point. All right, so that was document 23. Oh, goodness. All right. Now, as I said before, we do not have a document 24. There is no document 24 within the docket. So that's not something that I can share because there isn't one that's been on file. But that then takes us to document 25. So we are coming down to the final last couple of documents before the court orders from today, just to keep everyone up to date here. Yes. Oh, my poor mods. They're working so hard. I know. I know. You just got to kind of shrug it off a little bit. Yeah, well, no, I don't know about all that. But all right, so let's get into document 25. Government's motion for pretrial conference pursuant to the Classified Information Procedures Act. So this is the government, and I'm not going to spend too much time on this because we're only dealing with a handful of documents here. So, document 24 is the proof of his innocence. I doubt that. That would be a pretty powerful document. Oh, that's so very, very interesting. Yes, mysterious document 24. I think it probably was just somebody that filed something incorrectly. So anyway, yeah, let me just summarize this for you. This, is really just a technical piece. We've talked about this in regards to the Florida case. This is a huge issue, of course, in the Florida case because all of those 32 documents are all classified that he was charged with. And so, of course, we have to go through the SIPA Act, which requires special hearings to go through the documents in case the jury needs to see it. So here he's setting up the background of SIPA, why it's required under the law, that there is a hearing for certain pieces of evidence in this particular case. He's pulling out the different sections that require to have hearings regarding certain kinds of documents. And again, I don't need to read this word for word because it's just setting that out, that there is this requirement. So in conclusion, the government believes the parties can efficiently address any scheduling matters pursuant to SIPA on the same day as already scheduled hearing before the court on August 28th. So he's requesting to have the SIPA hearing that same day. And that must be, again, because there really aren't that many documents involved, is what I'm assuming. So that's really what number 25 is about. And again, we can kind of skip through that because it's just technical when it comes to this, these SIPA conferences that we've got much more of an issue with when it comes to the Florida case. So that takes us to document 26. So we are almost to the order that we got today. Let me just double check my documents here. Yes, the order that came out today is document 28. So almost there. Government's response in opposition to defendant's motion for exclusion of time under the Speedy Trial Act. Now, I've not read through this particular one. I wanted to kind of look at it with everybody else here. So remember when a little bit earlier I was reading how the defendant was requesting certain days to be added back to his speedy trial, his 70-day speedy trial. So this motion is the government saying that they are contesting that. They're saying they are opposed to the proposed dates with regards to his motion that he filed on that. Okay? Are we having some mod issues here? Are my mods here? Are you guys still here? We get a little heated here in the comments. We do. It's okay though. Everyone is, thank you for, oh, of course. I'm just pausing here for a minute. Oh, there you go, Mads. You're there. You're doing great. It goes so fast. As long as you're in there, I have complete faith in you. Oh, absolutely. It goes really fast. No, it's okay though, Serial Mom. It's okay. I mean, I think a lot of people, they get frustrated and they kind of lash out, and it doesn't bother me. But I know my moderators work so hard. You really do. Thank you so much for your time. All right, we'll get there. You're going to need extra cake tonight, Miss Moderator. Thank you for your time. So this is the government's, it's difficult. We have a lot of people with lots of different perspectives. So as long as everyone kind of stays within the guidelines, we're good to go. I feel pretty comfortable about that and have complete and total trust and faith in my mods. So, all right, let's dive in. So the government's saying, we do not think you should have the exclusion. So let's figure out what they've got to say. The defendant's motion for exclusion of time under Speedy Trial Act is unnecessary and premature and fails to recognize that the Speedy Trial Act protects the public's strong interest in the speedy trial. The motion seeks to exclude time from August 3rd to August 28th, but fails to recognize that all of the time since the defendant's initial appearance has already been and continues to be excluded under the Act. That's a valid point. Similarly, the defendant fails to acknowledge that one of his main bases for seeking to exclude time, that he will be, quote, filing numerous critical motions, end quote, and will in and of itself toll time. This is because a speedy trial under the Act does not necessarily mean a trial within 70 days. Rather, it means a fair and efficient trial within a reasonable period of time. Okay, that's a good point. Including appropriate exclusions for reasons such as time required for consideration of motions. The court should deny the defendant's motion without prejudice and reconsider the issue of exclusion of time under the Act when a trial date is set on August 28th. That's an excellent point, an excellent procedural point that he's making here. I think that's a very valid point. Here's the background. On August 1st, a federal grand jury in the District of Columbia returned an indictment charging the defendant with these different violations, which we've gone through the indictment a few times now. Yes, without prejudice, which just means it gives everybody time to reconsider everything after the trial date is set. So if it was with prejudice, it means they couldn't even ask the question again. And that's not what the government's saying. The government's just saying, we just don't have the right dates yet in order to figure out if you need that time back. The defendant made his initial appearance and was arraigned in the District of Columbia on August 3rd. At that hearing, defense counsel made an oral motion to exclude time under the act. On August 4th, which isn't necessary, I'm wondering if that's what he's saying, is that wasn't really necessary. On August 4th, the government filed a motion seeking the entry of a protective order in this case, so the very following day. By minute order, August 7th, the court took the government's motion and the defendant's opposition under advisement. So that all went down pretty quick, if everyone remembers that period of time. In addition, the court has ordered briefing by the parties on a proposed trial date, with the government's brief due August 10th and the defendant's due August 17th, with the expectation that the court will consider these briefs and determine a trial date on August 28th. Here's their argument then. The court should deny the defendant's motion because the specific relief requested, the exclusion of time between August 3rd initial appearance and August 28th scheduled hearing, already will occur under the operation of other provisions of the Act. August 3rd itself is excluded from the 70-day period. Under the law, the trial of a defendant shall commence within 70 days from the date the defendant has appeared before a judicial officer of the court in which such charge is pending. And then this is under Federal Rule of Criminal Procedure 45A 1A, excluding the day of the event that triggers the period. Here, the date of the initial appearance and arraignment from the 70-day clock. August 4th through at least August 11th will be excluded by operation of the defendant's oral motion for a speedy trial made on August 3rd. The government's motion for a protective order. So let's just take a minute before I get too far. We have on operation of the defendant's oral motion for a speedy trial. So the defendant's oral motion. Let's just keep that in mind. The government's motion for a protective order and the defendant's written motion for a speedy trial. So we have an oral and a written motion. Providing that any delay resulting from pretrial motion from the filing of the motion through the conclusion of the hearing on or other prompt disposition of such motion shall be excluded in computing the time within which the trial must commence. Finding no difference, the Speedy Trial Act proposes between a written and oral motion. Okay, purposes. For speedy trial purposes. Okay, so there's no difference. Because I was wondering about that, because we've got a written and an oral motion, so there's no difference between those two. August 10th through at least August 28th will be excluded because of the government's two scheduling related pleadings filed concurrent with this opposition brief. Therefore, it's unnecessary to grant the defendant's requested relief since the exclusions already exist by operations of the Act. Okay? More generally, the defendant's motion fails to recognize that the Act and the Sixth Amendment protect not only the defendant's right, but also the public's strong interest in the efficient administration of justice. Again, interesting arguments here. There is a societal interest in providing a speedy trial, which exists separate from and at times in opposition to the interests of the accused. To this end, none of the defendant's perfunctory and undeveloped arguments justify the court's exclusion of time at this juncture of this case. I think that's a fair point. I think he's bringing up a fair point here, again, because we don't have all the dates set out at this point. So the defendant cites his need to review discovery, but the defense has steadfastly refused to accept the discovery that the government has prepared and organized to facilitate the defense's review. His speculative claims about the time he might need to review discovery that he has not yet assessed does not justify exclusion of time. Next, the defendant claims to need exclusion of time because this matter raises significant constitutional issues and other novel questions of law and fact. And the defendant plans to file numerous critical motions, but the Act has built-in exclusions of time for precisely this circumstance. And when the defense files its motions, time will be excluded under this rule. In sum, the court seriously weighs the strong public and private interests served by speedy trial. The defendant's claimed speculative interests in delay cannot outweigh the public's singularly strong interest in a speedy trial. All right. And then, in conclusion, the defendant moves for the exclusion of time between his initial appearance and the hearing on August 28th that the Act already has provided by its own terms. Okay, so he's basically asking for time to be excluded that was already excluded, is what the government's saying. The court should deny the request without prejudice because it is unnecessary. Meaning, again, you would file it once the dates were properly set. Then, if at the August 28th hearing, the defense again moves for exclusion of time, the court should assess the argument anew, but as part of the required balancing of interests. Yes, I'm only reading it. I'm just reading it. I'm just kind of explaining what things mean and so on, including the public's strong interest in a speedy trial. So that is the government's response again. Oh yeah, no, these aren't my words. This is just what was filed with the court. So the next document we've got then is document 27. And this again, we've got notified that this attorney is appearing on behalf of the defendant. So that is document 27. Public interest is an outcome before an election. Yeah. I mean, I think it's, I think the public does want a speedy trial. I think it's a good argument for the government to make, but I'm not sure how much weight it's going to have. And maybe in federal court, it's more of a, it's maybe more likely to be granted. But in my jurisdiction, if I was to say, a speedy trial for the public interest, and my judge would just look at me like I was out of my mind. So I'm not sure. But again, who knows with what's going on? It's a really unique case. I think it's good to bring up these issues and to argue it out. A good faith argument. Yes. And the defendants requested it. He made an oral motion and made a written motion. So, with two of those motions, that's pretty, it shows that he is really very interested in that. This is the good one. Yes, we're there. We made it there. We made it to the end. This was the order that came out today. Yes, I really do highly recommend, this is all public. This is all online. You can go yourself and look it up. But one of the things that I think is really helpful for people is to see the actual document itself and to just see how they're set out. But, this is the docket. This is the case number. This is the entire docket here. And you can go online and find it also and look through it yourself as well. I try to be as impartial as possible. My view is that I'm here to just explain the law. I'm not here to pick a side. I feel like there are plenty of places that pick sides, and I just don't. I think it's more educational to just hear what things mean in different perspectives rather than kind of pushing one way or the other. Because my goal is for people to ask questions and for people to think about it. I just can't tell you how to think. Yes. Oh, thank you, Rosie. Oh, that's so kind of you to say that. Oh, yes. But that's definitely my goal. So I do try. Oh, beautiful voice. It's nice of you to say. Oh, I find, and some people have made comments before about my laugh, and I do chuckle sometimes, and I do laugh. And I guess when you have spent decades just wading through the absolute worst of the worst that happens in our society, you start laughing. You get to a point where, for me, that's how I come back to reality so that I don't remain lodged in the atrocities that, I've needed to prosecute or that I've needed to defend. So it's just part of my personality these days. So yes, and sometimes you have to laugh so you don't cry. Absolutely. But yes, true. I just, hello, Paralegal Life. Welcome. But I chuckle, and that may be off-putting for some, and I completely understand if that's not your cup of tea. But, I mean, I've seen some of the absolute most worst heinous things you could possibly see in actual real life, in a morgue, in a courtroom, in hospitals. So, I just got to a point where I needed to recognize that it's still okay to laugh, that you can still laugh in life. Yes, sometimes we have to. We really have to. So, gallows humor. Yeah, it's dark. Sometimes it gets a little dark. There's a lot of things, a lot of comments that we make to our colleagues and with the people in our office that would be completely inappropriate to share with the public, but sometimes that's how you make it through. So, yeah, it's a coping mechanism, and it's just become part of my just absolutely part of who I am. Yep, you're having a hard time finding the documents other than number 1. Okay, Persephone, yes. So you want to go online, go to your search engine, you put in US v. Trump and put in DC court documents. Now, I put it vague like that because wherever you're at in the country, it will pull up a couple of different options for you to click on. So you'll have to kind of hunt and peck a little bit through those options until you see a docket listed. And the docket will look like this, something like this. It might be a slightly different format, but it should look something like this. And then under each piece, there will be the main documents and various other things. And you can go in and print those out if you want to just click on them. So that's absolutely available for everyone. Yes, I am a lawyer. I am a licensed attorney in good standing. Oh, absolutely, Persephone. Absolutely. Is it normal to have jurors from DC represent a case outside of DC? No, it's not. No, we have jurors that are given a certain jurisdiction and in a certain location. And then our jury pool is pulled in based off of where they live in the jurisdiction. You don't pull jurors in from another jurisdiction. That would be incorrect. That's just not how our process works. It works for me, Mads. That's what that's what I've done. What do you think is next? I'm not sure. I'm not sure yet. I'm interested to see how she put this order together. Oh, sure. You are absolutely welcome. You're on the board or board? Oh, I'm not sure. On finding these documents. Oh, I could do that, Tiny Transformation. Would that be helpful if I made a post on where to go to find these? Sometimes it's really helpful for me because I don't know what people don't know. Honestly, I really just don't. Okay, yeah, sure. Oh, okay, I will do that. I will do that then. I'll put that on my list and do that. Yeah, I just assume that people, okay, yeah, absolutely. I certainly can't link it, but I can give you directions on how to find it. And again, that's because, everybody's kind of going to have different things that pop up when you do it. So, oh no, I'm not from any SCOTUS blog. Oh no, I'm just a lawyer. I'm just an attorney. I've done a lot of criminal cases. Oh, absolutely. I do a lot of criminal law. I do a lot of constitutional law, and I've also taught those areas for years and years and years. And I enjoy evidence and those kinds of things. So that's what I'm here for. That's what I do. I'm just here for education. All right, let's dive in. We've got the protective order here governing discovery and authorizing disclosure of grand jury testimony. So this is the order that came down today. We've got document 28 here. Order from the court. The United States has moved for entry of a protective order that would govern discovery in this matter. To expedite the flow of discovery materials between the parties and to adequately protect certain information that the United States intends to produce to the defendant, the government's motion is granted in part. So only part of the government's protective order or protective motion request, and denied in part pursuant to the court's authority under Federal Rule of Criminal Procedure 16D1. Which just is setting out that the court has the authority. So it is hereby ordered the following. First, no limit on already possessed or public documents, which makes sense. I do. Yes, I do have a tube of you, and this will be posted later. Number 1, the protective order does not apply to information or records that are publicly available, independent of the government's productions, nor does it apply to information or records which the defendant or defense counsel came into possession by independent means unrelated to the discovery process. Now, this was the same language, the same request that was in the government's protective order. Next, sensitive materials. Sensitive materials, which the United States may designate in accordance with paragraph 8 below, are subject to this order and may be used by the defendant and defense counsel, defined as counsel of record in this case. That was a question that had been raised by the defendant, was he had wanted to have different people be able to look at the documents. And so she's setting out the counsel is what's defined by counsel of record. So she's kind of making that clear. Solely in connection with the defense of this case and for no other purpose and in connection with no other proceeding without further order from this court. Okay, so she's, again, the government had suggestions and then defense had suggestions. And so she's kind of merging them together here. Let me just make sure. Am I in frame okay for everybody? I just want to just double check here. Sometimes when I flip the page, I get out of frame again. Just a tad out of frame. Okay, thanks for telling me. Yes, okay. Let me just double check here. Trying to readjust. Here we go. Oh, thank you kindly. Thank you very much, Raymond. Okay, how are we now? Is that better? Okay, excellent. Thank you so much. I need to put a little mark here so that I know where to put it back when I flip the page. I get so excited when I flip to a fresh page. Okay, so in this case, for no other purpose and in connection with no other proceedings. So that was one of the requests that the defense made, and she's saying, no, you can't have that. It needs to be counsel of record. The defendant and defense counsel shall not disclose sensitive materials or their contents directly or indirectly to any person or entity other than the persons employed to assist the defense. Okay, so that's further clarification because they again had said they wanted some a bit more wiggle room when it came to who they could talk to. The government had only said counsel, but now she's adding it's okay to add those assisting with the defense. Persons who are interviewed as potential witnesses, counsel for potential witnesses, and other persons to whom the court may authorize disclosure. Collectively authorized persons. Potential witnesses and their counsel may be shown copies of sensitive materials as necessary to prepare the defense, but they may not retain copies without prior permission of the court. I think this paragraph is a really good blend of both the government as well as defense. It's a good blend of different pieces here. The defendant, defense counsel, and authorized person shall not copy or reproduce sensitive materials, which was requested by the government, except to provide copies of sensitive materials for use in connection with this case by the defendant, defense counsel, and authorized persons. All right, so that's kind of a compromise there. Such copies and reproduction shall be treated in the same manner as the original, which was requested by the government. The defendant, defense counsel, and authorized person shall not disclose any notes or records of any kind that they make in relation to the contents of sensitive materials, other than to authorized persons, and all such notes or records are to be treated with the same manner as the original. Provided, however, this paragraph shall not apply to generalized mental impressions of authorized persons not reflecting on the content of sensitive materials. Now, this is an interesting... maybe tape your marker. Yes. Oh, that's wise. I wish I had tape. I have no tape. Sometimes I'm quite an absent-minded teacher at some points. I'll have to do that for the next one. So take a moment. I'm going to take a second here because this was really a point that they argued quite a bit about because the government had been very precise to say that the defendant could not take any notes and that if he did take any notes by chance, they would have to be strictly reviewed by his counsel. So that was a really big point, a sticking point for the government. But then defense had come in and said, hey, we have to put our defense together and that kind of control is really outside of what we need. So it sounds like, again, she has merged the two sides into this kind of middle ground for both of them. So I think that's really well written as well. Before providing any sensitive materials to an authorized person, defense counsel must provide the authorized person with a copy of this order. An authorized person must agree in writing to abide by this order. Both parties had already agreed to that. Upon conclusion of all stages of this case, all sensitive materials and all copies made thereof shall be destroyed or returned to the United States unless otherwise ordered by the court. I think that was also agreed upon. The court may require a certification as to the disposition of the sensitive materials, provided, however, this paragraph shall not apply to any work product notes. Again, this was another sticking point that the government had. So this is more of I'm looking at this as kind of like, did the government win this point or did defense? And it's looking like they're pretty evenly situated. This piece would be the government's. This piece would be a win for the defendant. If you go back through and look at those orders, which I won't spend much time on, but because I've read through them so many times. So this would be a win for defendant. This would be a win for government here, or other documents. And let me flip. Let me see if I can get back into alignment. Hopefully, let me see. There we go. I think I'm okay. Reflecting the content of sensitive material. The restrictions set forth in this order do not apply to the documents that are or become part of the public record. I think both of them had agreed to that, including documents that had been received in evidence at other trials. That's an addition. That's an additional piece that I think the judge added. Nor do the restrictions in this order limit defense counsel in the use of sensitive materials in judicial proceedings in this case, except as described below. 8. The United States may designate the following materials it produces to defense counsel as sensitive materials. So now she's setting out what sensitive materials are. This, again, was a huge controversial piece between the two sides. The government had said, we will go through and we will use our decision and kind of have everything be sensitive materials based off of our choices. Meanwhile, the defense was saying, you can't have everything be sensitive materials. That doesn't make sense. So here she's setting out kind of like the government did a little bit, but with some different points. So materials containing personally identifying information as identified in Federal Rule of Criminal Procedure 49.1, which we all know about that rule now. Rule 6 materials, including grand jury subpoenas, returns, witness testimony, related exhibits presented to the grand jury. Materials obtained through sealed search warrants. Sealed orders obtained by the government's filter team related to this case. Recording transcripts, interview reports, and related exhibits of witnesses' interviews. And again, you may remember from the defendant's order that he had requested that these kinds of things not be labeled as sensitive. So she did include that. And materials obtained from other government entities, which the defense had also requested that not be part of the sensitive materials. So she did include that. So I would say these were not necessarily wins, but these are part of what the government had requested. The government shall indicate to defense counsel in discovery correspondence or otherwise which materials constitute sensitive materials prior to or concurrent with disclosure. And that was agreed upon, except as provided in this order. Without prior notice to the United States and authorization from the court, no sensitive materials or information contained therein may be disclosed to any person other than the defendant, defense counsel, persons employed to assist the defense, which again, this would be what the defendant was asking for, or the person to whom the sensitive information solely and directly pertains, and that person's counsel, which again, I think is a really good addition that the judge made. Number 10, sensitive materials must be maintained in the custody and control of defense counsel. Defense counsel may show or provide sensitive material to the defendant as necessary. All right, let's see if I can get back into the proper picture again. Ooh, we're coming down to the end. All right. I think the judge is doing a really good job here, actually, of really compromising, of pulling from both sides' requests and kind of merging them together. To assist in preparation of the defense, and the defense counsel is not required to be present while the defendant reviews sensitive materials. Now, this was another big controversial piece between the two sides. The government had said defense counsel was supposed to have this ability to review everything with the defendant. Defendant was not allowed to be alone, essentially, with the materials, and she's saying that's not necessary. However, if defense counsel does show or provide sensitive materials to the defendant, defense counsel may not allow the defendant to write down any personally identifying information, which is fair, as identified in the rules over this particular rule, which again, 49.1 is that one we're trying to protect that kind of sensitive information, names, addresses, those kinds of things that's contained in the sensitive materials. So that sounds reasonable. If the defendant takes notes regarding sensitive materials, defense counsel must inspect those notes. All right, so this is a win, in my opinion, for the government. Must inspect those notes to ensure that the defendant has not copied down personally identifying information as identified in the rule of 49.1. So she did add that piece that the government had asked for, that the defense counsel would review, but just with relation to specific information about people. Moreover, during any time that the defendant reviews sensitive materials outside defense counsel's presence, the defendant must not have access to any device capable, ooh, that's an interesting addition, capable of photocopying, recording, or otherwise replicating the sensitive materials. This is an addition that I believe the judge made. I'm not sure that was in the government's motion, including a smart cellular device. Defense counsel must also ensure that all sensitive materials are collected and safeguarded when the defendant is no longer reviewing them. All right, so that also, I think, was a request made by the government. So I think the government had a few more wins in this section than defense counsel did, but it also seems like a couple of compromises were made as well. In my opinion, just looking at, the fact that we've read through both the government and the defense requests. Whew. Oh, I don't know that we can all get along. Not sure you trust his attorney to check his notes. Well, and that could be. But what the judge is saying here is she's saying, if I'm telling you, you need to take a look at it just for this particular thing. And then if he doesn't and that information comes out, then defense counsel can be held in contempt of court. So this is more of a check, really, than one of those assurances that he would make sure it didn't happen. But, absolutely. All right, the parties may include designated sensitive materials in any public filing or use designated sensitive materials during any hearing or the trial of this matter without leave of the court, if all sensitive information is redacted. All right, I think that's a compromise, and the parties have previously conferred and agreed to the redactions. Okay, so that is, I think, wishful thinking. I hope that happens. So I think that's great. She's saying you can use this because the government had said you can't use any of it. And defense said we want to use whatever we want. And so she's saying you can use it, but it needs to be redacted. And you both need to agree to the redaction. It's very interesting how she said that. I think it's great. No party shall disclose unredacted sensitive materials in open court or public filings without prior authorization by the court. Makes sense? Except if the defendant chooses to include it in a public document, sensitive materials relating solely and directly to the defendant's personally identifying information. I think that's also an excellent point. If a party includes unredacted sensitive material in a filing with the court, they shall be submitted under seal. So that also makes sense as well. So she's really kind of setting out this protocol that she wants to have done, and it seems pretty fair. So the defendant gets to use the materials however he would like to. It's just we have a couple of safeguards in place, so both sides should be satisfied with that, hopefully. Any filing under seal must be accompanied by a motion for leave to file under seal as required by Local Rule 49, as well as a redacted copy of any included sensitive materials for the clerk of court to file on the public docket if the court were to grant the motion for leave to file under seal. That also makes sense. Yes, thank you for that, Mads. Yeah, that was definitely something I had been wanting to remind people of. You can kind of get those comments off the screen if you'd rather just see the document. All right, so far she's done, I think, a really good job of trying to meet both sides' requests or their intent behind the request, not necessarily the form of what they wanted, but to meet what the idea was that they wanted. Scope of this order. Modifications permitted. Nothing in this order shall prevent any party from seeking modifications of this order or objecting to discovery that it believes to be otherwise improper. No waiver. The failure of the United States to designate any of the materials as sensitive upon disclosure shall not constitute a waiver. That was also in the government's request. Or the United States' ability to later designate the material as sensitive. No ruling on discoverability or admissibility. This order does not constitute a ruling on the question whether any particular material is properly discoverable or admissible, and does not constitute any ruling on potential objection to the discoverability of the material. And that's also just a housekeeping rule here. Challenges to specific documents. The defendant may raise particularized concerns about specific documents by a motion to this court. Signed by the judge. I think she did a great job. I think both sides didn't get everything they wanted, but I think they did get, both of them got pieces of what they wanted. So I think she did a pretty good job. In my opinion, after looking at both sides of the documents and how she kind of put them together, I think she did a pretty good job. How would you compare her to Eileen Cannon? After looking through, and of course I've read all of the documents for both judges, Judge Cannon's got a little different way of looking at it, but both of these judges are incredibly intelligent. They're both very organized. I haven't seen as much from this judge as from Judge Cannon, so I'm not really sure what the future is going to be for this one compared to Judge Cannon, because there are a few things with Judge Cannon where I'm like, interesting. She's kind of carving out her own style, and I don't yet see this judge's style herself, but I think it's coming. But I think both of them seem to have a very well-organized way of putting things out. Judge Chutkan, I always say her name incorrectly, but I really like how this judge really blended everything. And it seems like Judge Cannon just kind of goes her own way rather than blending or picking which side or kind of merging it. Like this one seems more cooperative, and Judge Cannon is more like, this is how it is, we're going to just get her done. Which both styles are great, just different. Oh, sure. Yeah. Oh, they both are incredibly intelligent women. And I'm looking forward to seeing what comes from it, because I can appreciate how closely both of them are following the rules, and those rules of criminal procedure. I think they're doing a great job with their different sets of rules respectively. So in my opinion, will the jury be given any type of clearance? Yes. And that's what the hearing is for, the SIPA hearing that they're requiring. Even though it's going to be short, so there may only be a few documents involved, but the jury will have to have a certain kind of clearance, or the documents will have to be redacted in a way that makes them safe for the jury to see. As far as the DC case goes. Now, the Florida case, because that content is so critical to the case itself, that's going to be very different. So that jury will have, I think, probably much higher level of clearance allowed for a short period of time than the jury in DC, I would imagine, only because of the nature of the charges. Come across as clueless and biased. Well, I don't know at this point. I think both of them are pretty, they're both new. And I think that's unfortunate in some ways, because I think they're both going to be kind of really questioned quite a bit more than if they had had more years of experience. But on the other hand, judges do, it takes a while for them to really get their sea legs, so to speak, or their land legs, whichever way. But, well, in this kind of a situation, I think she's had a huge quantity of cases that have come through, but a case at this level, I think she's really had a condensed experience rather than a long-term experience at this level. There's Travis. That's a good question everyone's asking. I think the charges come with time, but whether or not that's appropriate, I have no idea. And again, we've not gotten to a point where we're beyond a reasonable doubt, and so there's really no way to assess that at this point for me to do that. Some people have a better way, but well, I think I think it is interesting. It is interesting that we have in both of these huge cases that we have women judges. I mean, I just think it's interesting. I think our stats as far as the number of women judges that we have really shifted in the last 10 years. And I think this really shows it, just because it was, the luck of the draw for both of them. Yeah, I think it's interesting. It's interesting to have the women sitting there as the judges on these cases. I don't think people reason the risk the legal team on either side, including the judge. Yeah, I think you could be right for that. You could be right. Women should be in charge for sure. That's a good thing. Perhaps. I think it definitely is something that we would not have seen 10, 15 years ago. I'm not sure. We've got a DA in Georgia. Um, and the Georgia, I think the Georgia attorney or the Georgia judge, I'm not sure. I think the Georgia judge was also, but it is interesting, and I think it's statistically it's showing that the numbers are evening out just a little bit more than what they used to be in the legal field, because it really is an incredibly male-dominated field. It just is, and particularly in criminal law. So it's, I think it's very interesting to see that we've got this kind of split on judges. Mm-hmm. Yeah, it is. But sometimes, EJ, it does take a while, but it eventually happens. That tends to be kind of the theme of this country, is that it may take a while, but we get things kind of sorted out. Yes, I've seen some of those statistics, Turbo. I've seen that those numbers have switched a little bit, which has been, very interesting to see. Oh, hello, welcome, welcome, welcome. Yeah. Well, it's hard to generalize too much, but I think the idea that we've got so many just strong, capable attorneys and judges that are women, so much more than what we used to have. It's fascinating. I think it's very interesting. Glad. Oh, good. Thank you. Yes, thank you for joining. Thank you for joining us as we go through this. So, taking a look at the order that came down today. Again, I think her protective order is pretty well balanced. I think she really, again, puts what both sides wanted into a format that kind of worked for both sides. I think so too, that she's showing her dedication. Absolutely, absolutely. This live has been awesome. I'm so glad. Oh, thank you so much, Kimberly. I'm glad you're here. I'm so glad you're here. Oh, thank you. I do try with the explanations. I try to make it, available for everyone. Again, everyone will have to decide for themselves what they think is, what's the best thing for everybody, but I can at least show you where it's at. This judge seems fair. She does. And I wonder, though, if Judge Cannon hadn't made the mistake she had made previously, if people would have thought, would have been less apprehensive about her. And I think that that's kind of the nature of the situation when you're a new judge, is you're going to make mistakes. And hers was a pretty big one that kind of bumped her into the being questioned pretty significantly. And I can understand why. Awesome life. Oh, thank you so much, PWM. Thank you. That's so nice. Yes, I think there are at least 20 million opinions. And, if somehow someone just hears a little bit about the actual document, hopefully that will help them to make a good decision. The witnesses said they don't know about them. Oh, I don't know about that. I don't know if she's going to recuse herself or not. I mean, again, I don't see any grounds of that. For the typical reasons why judges would recuse themselves if they've got conflicts, and I certainly don't see any conflicts at this point. Can you summarize what he's allowed to talk about in public now, please? Sure. Oh, absolutely. Is that Korn? You know how I feel about Korn. I'm a big Korn fan. Thank you very much. Oh, look at that one too. Fireball, lovely. All right, so it seems like under this order, anything he had already gotten or anything that had already been made public before, all of that is open and available. And if you remember all of the congressional hearings where they had the testimony that was, broadcasted, all of that information is open and available. So what he can't talk about are anything that the government produced essentially in putting together the case. So grand jury information, witnesses that were done that were not done in public, but that were done by the government. Those kinds of things will need to remain private at this point. Those will probably all be labeled as sensitive materials. But anything that's already been out there or has been made public in some kind of manner, or that he already had, sounds like that will be available. He doesn't have to be careful about necessarily making sure that that's allowable or not. Understands the weight of everything she does under. I think so. And I think a lot of that comes from the experience that she had with the all of the cases that she's been doing in the last year. Judge gave you a warning. Well, sometimes they do that. Is there no mention of threatening statements? It seemed like she had made the judge in this case, and again, I'm so worried about saying her name wrong, but Judge Chutkan, I have to keep saying her name. Judge Chutkan had made several oral statements at the time of the hearing today. So the hearing was almost 2 hours. It was, I think, an hour and 45 minutes. And she did kind of verbally say, based off of what I can gather from different sites, she did say, you need to be careful. And, I just kind of sent out a cautionary note to the defendant and said, look, we're all keeping an eye on you and you need to, be careful about what you say. I had pulled a particular statement. She had said, with regards to the First Amendment, she said, and this is a quote, "No one disagrees that any speech that intimidates a witness would be prohibited. What we're talking about is fair use of information." So that's a direct quote that she said. She also was quoted to say, "The fact that he's running a political campaign currently has to yield to the administration of justice. And if that means he can't say exactly what he wants to say in a political speech, that's just how it's going to have to be." So, and then lastly, another quote that I thought was pretty good was she said, "He is a criminal defendant. He's going to have constraints the same as any defendant. This case is going to proceed in a normal order." So those were some of the additions that she made during court when she was in court talking about that. Heard the government lost all the evidence. Oh, no, that's not true. Not true at all. Yeah, I think so. Oh, thank you so much. Oh, for your kind words. Thank you so much, Renee. I appreciate that. It's very nice of you to say that. Very nice. I appreciate that. I'm trying to catch the comments here. Oh, my goodness. Thank you. Galaxy hearts. Very nice. Oh, my goodness. Yeah, I thought she did a really good job. Yes, I try. Oh, thank you, Andrew. That's very nice. I do try to just kind of, just give you the information. Again, I think everybody's got to really kind of process the information and make up their own minds about things, but I can at least help people understand. I don't think we make it easy for people to understand our legal documents and our legal process. So I hope at least there's some assistance with that. And honestly, I feel like a lot of the problems that came out of these situations in Florida and in DC came because of a misunderstanding of how the law works. And so if I can kind of help a little bit, just a little tiny bit, I'm hoping to be of some assistance. So, Oh, well, thank you. Oh, thank you, Amos. Very nice of you to say that. What happens if either side breaks the protective order? Are they in contempt? Yes. They would be found in contempt. And if you get found in contempt, you can go to jail. Absolutely, you can. Lots of documents. He has too many documents. We need to read them all and process this and get them. Yeah, I mean, whatever's public is open and available. There is a huge report that was given by the January 6th committee. And I know some people have been reading that on TikTok. I have not caught that. I've noticed a lot of people reading more of the documents, and every time I see a TikTok where someone's reading a document, I'm like, woohoo, awesome, that's so fantastic, I love that. But I have not heard it yet. That's kind of on my list. Will I be on tomorrow? Probably not. I've set a schedule. I'm going to try Mondays and Thursdays, unless a particular, interesting order comes down. The last couple of weekends, we've had some orders that have kind of been fought through the court, even over the weekend. So I would come back on if something comes on, but I'm going to try to kind of just keep it to that Monday and Thursday schedule. Just, I've got to I was taking a look at my desk today. I'm like, oh my gosh, I got to get back on top of my work. So it's so much fun for me. So, it's hard for me to kind of put a limit on it, but on the other hand, I suppose I gotta pay the bills. They do like to do things over the weekend, Cozy. They do. They do. So we will see. So with the evidence you see, would you take this case? No. No way. No way. Are you kidding me? I've heard there's over 1 million documents. No way am I reading all that. That's crazy. That's madness. Nope. Nope. Who cares about that? Well, true. What about J6 people deleting their evidence? No. No, I'm sure the evidence is already there. The evidence is already there. Yeah, not with a 10-foot pole. Yeah, all the evidence is there. All the copies of the evidence, all the originals. I've got no doubt that the government has so much evidence that, there's just like truckloads of evidence. So I have no doubt about that. Oh, Lewis, that's so nice of you to say. You've read at least 20 documents. At least 20. More than that. Many, many more than that. And this is only a sliver of what's out there. Appreciate the work here. Oh, thank you. Thank you so much. Thank you. I'm glad it's helpful. I'm glad it would be that it's interesting for people and of some value. So I'm thankful for that. Yes, I do. I do giggle. Oh, but you all are so fun and so intelligent. I just love chatting with you. Yeah, it would be. It would. Oh, I'm glad, Rosie. I'm hoping it's educational. I'm hoping it is. I have a life such that it is. It's the life of a dork, so it's not that exciting of a life, but I do have a few things on my schedule that I do need to kind of take care of from time to time in between my lives. Oh, they say it's the evidence that January 6th was staged. Nope, that's just not true. Yeah, just not true. How strong are their federal RICO charges? I have been like chin deep in RICO this last week, and I'm still trying to figure out that statute. And so at this point, I'm not really sure. I'm really hesitant because we haven't gotten word from Georgia yet. So I'm going to reserve judgment until Georgia. I've got a feeling Georgia's going to be coming out pretty soon. Pretty soon. Oh, you're welcome, Real Life Works. You're welcome. I'm glad it was helpful. Yes, I think so. Ghost of John Adams. Thank you, sir. Hopefully you found some peace as a ghost. But yes, I think it is helpful when you actually see the language itself and you just see that, make sure to drink some water. I will, absolutely. But when you see it for yourself, I mean, that's really what it's all about. You don't have not that there's anything wrong with journalists, but I'm just saying when you see them summarize things when they're talking about it, which can be very helpful. But when you see it for yourself, I think it gives you the chance to really process the information. A proud dork. Yay! Dorks unite. Do you post your lives anywhere? Yes, I have a Tube of You channel that I put all of my lives up on. So long as Dorks and Docs. Oh, that would be great for merch. But I do put them up. Not all of them have gone up. If the documents are completely not readable at all or there's something wrong, then it won't go up. But typically I do try to post within 24 hours. I try to keep them so that people can go back and look and kind of fast forward and so on. So hopefully that can be helpful for people if they've missed certain pieces and so on. Where they make the news and there's always something wrong with the facts. I found that, or at least the facts are presented from a particular perspective. And I think if you get them from a particular perspective, you're not necessarily getting all of the facts. But if you just see it written down, like, that's how it is. So that helps me. That helps me a lot. Yeah. And sometimes they do just skim the docs. And a lot of them, I mean, they're not attorneys either, which, not everybody can be an attorney. And so they may think that something means something when it actually doesn't necessarily mean that. So that's why I think sometimes it can be helpful to have someone just go through the legal language and explain what it means. So yeah, I hope that it's helpful in a partisan. It really is. The news, I understand where they're coming from, but for me, when the law comes into play, I don't think that there's really much place for politics in how I view the law. That's just my personal belief, how I go about teaching and explaining things to people. So I think it's a lot easier to understand when you just get just the facts, just the law, rather than kind of the opinions that can come with it. Sometimes opinions are good too, but Sometimes just the facts are okay. Yeah. Yeah. And again, to be able to go through and read it for yourself and to know that these are the words of the judge. I mean, it doesn't get more clear than that. Than the language of the judge, or the motions on for the defendant. Those are the defendant's own words in those motions, and the government as well, so you can really see how they go. Do you believe he would ever be held in contempt, or just a warning after warning? Bobby, I think that's an excellent question, and I feel like the tone of this judge, she is really has set out some strong boundaries. So I would say it would be possible for either side to be held in contempt by in DC. I'm not sure about Florida, but I would say for DC, it seems pretty. She seems pretty clear about it because she has continued to say it. In fact, there was a little bit of not a spat, but a dispute between his attorney and the judge today over that. And she just said, look, you can keep talking, but I'm going to just say the same thing over and over again. So I think she's good at kind of putting Dorks for Justice. But I think she's good about putting her foot down, and I can respect that. I think both judges run the risk of kind of getting pushed around by the government as well as by defense. So I think both sides have this potential to kind of push on these judges a little bit. So, but I think Judge Chutkan's going to do a good job. I'm still deciding on Judge Cannon, but so far, she hasn't done anything that's led me to believe she can't be impartial. Why do they not do the same with I have no idea what you're talking about, Alan. Sorry. I'm not really that familiar with how things work in Georgia. To be honest, Dorks for Justice. I'm gonna get that on a t-shirt. Let's do that. Let's get football jerseys. Dorks United. Oh, that could be like a rugby team. Oh, I'm busting with anxiousness to see if the defendant can stay in line with the judges. NASA baby, you are not alone. You and a lot of other people are just, I think we're all a little bit like, what's going to happen? I think we really all are. But, and it's understandable. I'd buy that jersey. Me too. I would too. Where do I practice? I am in the Central Time Zone. So I am kind of in the, just in that middle time zone. That's about as specific as I get. I like to stay a little bit mysterious. So did the judge add a fine for violating the order? No, but it would be a typical, whatever they do typically for their contempt in their jurisdiction, whatever their local rules are for that is what she would go forward on for contempt. So in some places it's a fine or jail and certain amount of time for jail. So that would be, what she would be looking at is whatever their local terms are. Oh, you're in the Central Time Zone too. Oh, good, excellent. So you're haunting the middle of the country. Thank you. Very good. Are the bookies taking odds? I don't know, but it'd be interesting. You're on the East Coast. Oh, okay. Excellent. Bible Belt. Okay. That's a strong belt. Yeah, you do your part. Excellent. I love to hear that. I love that. Oh, you too, Michelle. Okay, excellent. Central. Okay, yes. Okay, I didn't want to make any assumption with the Kurds, but it sounded like it could be. Yes, some are 1,000, some are up to 60 days. Like in my particular jurisdiction, I think we're at 750 and up to 30 days in jail for just a regular contempt. But that would be the maximum, and they typically don't do that. Yeah, it's a strong belt. That particular belt is one of the stronger belts. Oh, Pennsylvania. Very nice. Oh, in Maine. Okay. We've got lots from the East Coast then. Can a defendant obey the judge's restraining orders? Recommend a betting pool? Maybe not legally. I'm not sure if that would be a great betting pool, but I don't know. California, Georgia, Texas. Okay, great. New York. Oh my gosh, from everywhere. Oh, formerly from Maine. Oh, you're from all over the place, everybody. Nice. Ohio, nice. South Carolina, Tennessee. Oh my goodness. Utah, Maryland. Oh, Australia again. Delaware. Wow, we got a lot from all over the place. Nebraska, nice. Cornhuskers, I hear you. Pittsburgh, Wisconsin. Indiana, Texas, South Texas. Okay, Utah. Yes. Oh my gosh, look at that. Indiana, Virginia, the Midwest. Yes. Georgia, Canada, Michigan. I love that. I love that. Colorado, Texas, California forever. Oh, Daytona Beach. Oh my gosh. Southern California, Tennessee. Okay. Awesome. Texas, Colorado, Georgia. Oh, Louisiana. Oh, you've got some interesting laws down Louisiana, Washington, Missouri, New Zealand. Oh my goodness. New Jersey, Purgatory. I got you. Well, you did have that uncomfortable fight with with Thomas Jefferson, so I can see why. Pacific Northwest. Oh, Iran. Oh my gosh. Oh, I love that. New Mexico. All right. Mysterious. Rhode Island. Oh my gosh. Yes. I love it. Oh, I love it. Thank you so much for joining from all over the place. Lone Star State. All right, I got you. I am originally from San Antonio. I worked very, very hard to get rid of that twang. Very hard. When I moved. Yes, USA. Yep. From all over. Oh, that's fantastic. I love that. I love that. That is just wonderful. Yes. Corpus Christi. Okay. Yes. Oh, yes. Lots of people from Tennessee. I love that. Okay. Oh, my gosh. Well, thank you all for coming. Lived in San Antonio. Okay. Yes, Army. Yeah, my dad was Army. Keep the twang. It comes back. It comes back. Once I talk to my dad for a little bit, twang comes back. It takes me a while to get rid of it again. Oh, I went to visit my dad down in San Antonio for just for a week, just visiting him and family down there. And I came back and my significant other was like, seriously? How long is that twang going to hang around? I'm like, just give me a time. Oh, Hawaii. Yes. Oh, my heart goes out to them. Absolutely. Oh, in Germany. Okay. Welcome. Welcome. Definitely with Hawaii. Been watching that very carefully. Very careful. There are some pretty amazing people that I've met that have been from Ohio. Now, I can only speak to those people, not generalizing, but yeah, I mean, there's just all kinds of different, it is with Hawaii. I mean, the history and, it's painful. It's painful. They've had some problems with wildfires in the past, and I think this is really showing like what happens if you don't kind of take care of it when it needs to be taken care of. So, oh, you're from Ohio. Oh, good. Oh, I love it. I love it. Oh, yes. I have a very, very, very dear, sweet friend from Meigs County. He's one of the smartest people I've ever met in my life. He's amazing. Spent quite a bit of time in Texas. Yeah, okay. Yeah, the climate change, that, that's not helping for sure. There's a lot of things at play there, but definitely painful. Hard to watch. Just send in lots of help in whatever way we can, I guess, down to them. So, oh, absolutely. Oh, I'm Ohio again. I love that. Ohio's representing tonight. Yes. Well, I'm happy to come on and help out wherever I can, as much as I possibly can. Yes, applause for the voters. Yes, well done, Ohio. I'm however people decided to vote, I'm so impressed with the sheer numbers. I just think that that's fantastic. I mean, the more people that go and vote, the more, the system works. So I just love that. I absolutely love that. Yes. Oh, absolutely. What do you do besides reading court papers? Well, I have my whole TikTok world is really just on cases and Constitution and different rules. I try to do historical cases, but also current SCOTUS cases and just general education about the law. I've got a very heavy focus on constitutional law, but my lives lately have been really spent kind of explaining legal documentation. So I've taught evidence for years and years and years. So it's just one of those areas that I just really enjoy sharing with other people. My favorite flavor of ice cream? I don't know. I mean, if I had to choose, I would choose just cake. Can we just put cake in the freezer and then just eat the cake? Is that okay? Can I do that? instead of ice cream. Oh, oh my goodness. I've said too much. I've said too much. Thank you for your comments. Oh, you're welcome. You're welcome. Absolutely. Oh, yes, I do have a lot. Oh, frosting. Yes, I can't help it. I just absolutely love. Oh, you're teaching civics. Oh, excellent. Oh, absolutely. I've had a couple of different universities, a couple of different places that have asked if they can use the content. And I'm like, absolutely. Everybody just use it, adore it, enjoy. I think that's fantastic. If you could share it. I love to share all my favorite TikToks with other people. So I'm just so, it's such an honor, honestly, for other people to think it's good enough to share with others. I'm very touched by that. You understand the Constitution? I do. I have, I'd say maybe about 250 posts on the Constitution. It'll take you a little while to get through. But each and every single one of the amendments, all of the articles, lots of case law. Oh, homeschooling. Yes, absolutely. Absolutely. And it's nice to have kind of bite-sized pieces too, that micro learning. I'm all about that. Ooh, wedding cake in the freezer. Yes. 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 I'll take that. Oh, New Jersey. Oh, fantastic. Oh, that's great. I love that. Now I'm wanting wedding cake. Can you just order a wedding cake, or do you have to have a wedding in order to order the wedding cake? Probably should have a wedding. I'm fine getting birthday cakes, but maybe a wedding cake would be too much. No, I'm all about the cake. I'm all about, oh, Brazil. Welcome, welcome. How long have I been practicing? A really long time, like an obscenely long time. I haven't. It sounds like one of those AI. Oh, well, that's interesting. I've not heard the AIs. I probably should dig into that, but I'm afraid that I'll get caught up into something that I'm uncomfortable with. So I choose to not go down that road. Oh, buttercream frosting. Oh, yes. Or the champagne frosting. Have you ever had that? Oh my gosh. Yes, I probably talk about don't get involved with the AI. Oh my gosh. Yes, yes. Yes. Oh yes, absolutely. I think that's wonderful. I think the more knowledge that you can have about the legal system, the better. I just love it. I love it. I think that's really great. Colorado wedding case, dream or nightmare. It's a mix. It's a mixed bag. It's a mixed bag. There's really, I don't know. For some points I can see what they're saying because of the precedent, but then I'm not sure the precedent was really decided in the best way. So I'm still undecided really on that one. Voice is perfect for AI. Well, that's good to know. That's good. I think somebody said I could do Audible books. That would be fun. I'm not sure though how interesting that would be. I probably would laugh too much, I think, to be serious. How did it end up a case without a real plaintiff? For the website, it was because we had let's see, how do I put this? There's a couple of ways you can bring cases. And one is if you have an actual injury, but the other one is if you believe you have, you could be legitimately charged with something. So what she was saying was, even though she wasn't charged because of how Colorado had enforced the statute previously, that she would be facing sanctions. That met what was required for standing for the lower court, and it wasn't really raised at the Supreme Court because it was already decided and stipulated to. So that's the short answer to that, but it can happen. And sometimes those kinds of questions do come up when we've got constitutional law questions. They're like, well, I haven't been charged yet, but I could get charged. I don't want to deal with it, so let's just sort out the issue right now. An emotional support chainsaw. I was trying to think of what kind of a weapon I could use in the scenario that wouldn't get pinged from the TikTok land. So I was trying. Oh, so yes, the chainsaw. One of my favorite sayings is knowledge is power. Oh, it is, Christine. It really is. It really is power, I think. And it's empowering too. I wish I could say that word correctly, but I think it really helps you so you can feel more comfortable. Can hold him while the court goes on. Yeah. I think so. Can that hold him? Yeah, I think so. Do you mean the protective order? Is that what you're talking about? Did the chainsaw guy get sentenced? No, the jury's still deliberating. Oh, yeah, that's funny. I've heard he could run the country even if serving in prison. Well, I don't know. There's this kind of like view of technically what could happen, but then there's also the view of like how many legal orders would be filed. So I think it would absolutely be debated legally by quite a bit. Oh, Veronica, you're welcome. You're very, very welcome. Hello, Dilly Bean. Welcome. Can he pardon himself? No, I do not. I do not think that's how our pardons work because of the language. And also, if you look back to a lot of those early documents when they were kind of figuring out how to do the pardons and how that was going to work, the intent was not to protect the president himself or herself from criminal liability. And that was cited in the U.S. v. Nixon case and Clinton v. Jones also. Some of those early papers. The court system, well, there's problems with it. True. I would not say that I can't say we don't have problems, but I would say what's better? What's better? Yes, we had an order. The protective order came down today. So that is online and available. I read an article saying he's ineligible to run. I think that's being talked about a lot right now. There are several different scholars coming in and talking about that and what exactly that third clause of the 14th Amendment meant, what the intent was behind it, and if these kinds of charges would qualify for that or if a conviction was needed. So I think that's kind of an ongoing debate. There's no definitive answer at this point, but it's certainly something to be talking about. And that, a lot of people are going into. Do I have a side on this? I don't. When I'm presenting any of the information on TikTok or through anything, I do not pick a side at all. I don't think it's my place. I leave that side up to everyone else to choose. I just kind of give you the information so other people can pick whatever size they would like. Yeah, we haven't been here before, so it's brand new. Can I read the 14th Amendment? Of course. Absolutely. Let me just grab it. You don't have to ask me twice to read the 14th Amendment. All right, so let's see here. We've got the 14th Amendment, Section 3. So no person shall be a senator or representative in Congress or elector of president and vice president or hold any office, civil or military, under the United States or under any state who, having previously taken an oath as a member of Congress or as an officer of the United States or as a member of any state legislature or as an executive or judicial officer of any state to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or given aid and comfort to the enemies thereof. So the debate that's going on is what exactly it means by being engaged. Technically, we have, how we've defined insurrection and rebellion, and we've got a couple of different ways we've defined it. But this idea of being engaged, does that mean convicted of that? And if not, is there a due process element involved? So I think those are the kinds of questions being asked about that section of the 14th Amendment. There's no charge of insurrection itself, but what some of the arguments are saying is this kind of obstruction of justice would fall under the broad term of insurrection. And even though insurrection and sedition haven't technically been charged, the elements involved in that are still possible here. It's just they weren't charged. And a lot of people think that they weren't charged because the government wanted to keep it nice and clean. Just keep it nice and easy. We've got a couple of things here, a couple of elements, not too complicated. And then, once that went to jury to see how that went, then could follow up with potentially charging those technical pieces. So, you're welcome. Absolutely, you're welcome. Never let that argument stand. Never. Well, Jim, here's the key with SCOTUS. They have to have jurisdiction to hear the case. They can't just pick and say, oh, this case is interesting. Let's go talk to people about it. They have to have jurisdiction. That's the law. So in order for them to hear the case, in a federal case, they're essentially an appellate court. So we would have to have a particular finding in this court, and then that would need to be appealed, that there was some kind of a federal law that was at issue or constitutional question. And then after that, it would have to be appealed again all the way up to the U.S. Supreme Court. So they would hear it as an appellate question. They can't just kind of swoop in and say, hey, stop. That's just not how their jurisdiction works. And that's just clearly what's been set out in the Constitution and the judicial acts. So, yeah, I mean, it's just, oh yeah, Thomas Jefferson was a really interesting character. What law is in the charge? The biggest piece, there's several. One is, defrauding the government with these fake electors. The other one is kind of this idea that there was a hindering of the right to vote. So we have a charge under the civil rights section of the U.S. Code. But the big one is obstruction, which was an interference with a government function. So it was the literal interference with the January 6th meeting of Congress to go forward with the electors. So that's what the charges are. What about aid and comfort? Aid and comfort to the enemies. So that gets more technical because how enemies is defined has been put into different statutes. Yeah, I mean, it's a good question, but actually to be defined as an enemy of the state or enemy of the United States is relatively specific. Well, hopefully this protective order will serve its purpose. I hope it does. I hope that he doesn't really get into trouble. I mean, I don't wish any trouble on anyone. Bush v. Gore, it was a matter of 500-ish votes, and Gore conceded the election. There were so many things going on with Bush v. Gore, but I think ultimately it really came down to the U.S. Supreme Court saying that the lower court couldn't force recounting, that it needed to be taken care of in a different way. That was really what that case was about. Gave aid and comfort and love to the protesters. True. And, many of them, I mean, I think what they say over 1,000, could they qualify as enemy of the United States? It's possible, but I don't know. I mean, I think it's really debatable. That I would think is the weaker of the two arguments. I think the engaged in the activity of insurrection and rebellion, I think that would be easier to prove than giving aid and comfort. I'm just thinking, I think both of them could be argued, but I think the first one would be an easier argument. Yeah, I mean, because it's so debatable. I think they're both worth arguing, but I think that first one would be an easier route. Many of them did end up in prison. They did, yeah, and they were convicted of some pretty serious crimes. Many of them. So, there's definitely elements there of it. I think again, it's always good to bring up those issues, especially on something so serious. But, yeah, I mean, it's not, it's kind of a tough, this whole thing is tough. This whole thing is just awful. I didn't think I would ever see anything like this in my lifetime. And again, even if there's no finding of guilt, just the level of charges and information that's coming out. I mean, even without a conviction or anything like that, it's still like, wow, this is really unbelievable. It's tough to think that, it's tough to accept that something like this has happened, I guess, is a better way of saying it. It's more like it's hard to wrap your mind around the memos and the fake elector certificates. I mean, those are actual tangible pieces of evidence that were created. And for me, it's hard to say, like, somebody actually put this plan together and thought about it. Now, who did and how it went, that's something else. But if you just look at the evidence, like these pieces of evidence were created, and for me it's so disappointing. So that's really what I mean by it's tough. Right, exactly. Yeah, none of us would want to be here. None of us would want that. Yeah, pieces is good, Suze. That's smart. That's very smart. Just a little bit at a time. Just a little bit, for sure. Do you think the internet plays a strong role in several lawsuits since it became affordable? Oh, that's a valid question, and I'm not sure, honestly. I'm really not sure. Our legal system is definitely behind the curve when it comes to technology. I mean, our judges and, we struggle to catch up with everyone's technology. But so I think there is definitely a lack of knowledge, but I'm not sure if that's increased the reason that we've got litigation. I'm not sure. That I would have to think about that. I think that's a thinker question. That's a question I'm going to need to think about for a little bit. Excellent question. Yeah. Yep. Yeah, it really is. It's a difficult fact pattern to look at in to try to figure out how we got to this point, I guess. Yes, Lawyer Adam, thank you. Thank you for coming. Appreciate that. What happened to the justice system? Nothing. I think it's other than it's become more exposed. I think the light's been placed on the justice system. But for those of us who've been working in it for a very long period of time, it's none of what's happening in the justice system is particularly new to any of us. Only the people that said that we were paranoid or making a big deal out of nothing are like, "Ooh, you're right." I'm like, yeah, well, that doesn't really help much. But the dishonesty is hard to wrap your brain around. I think so when it comes to the Constitution and how it was so manipulated in this situation. I think there's evidence obtained by hacking should be admissible if it's 100% proves a crime. I would need corroboration. I would need I would need more than one source to prove that it was legitimate. And I think that's my own bias, I think, about electronic discovery and how people go about getting it. So I would need more than just one piece, but I think it could be used in conjunction with other pieces to prove it. But I tend to feel that way about all kinds of evidence, though. I want to see, lots of different pieces of evidence and different types of evidence in order to prove something. Happens to a case like this if the defendant... Ooh! Well, that's a good question. But if we don't have a defendant, we have to have a defendant, literally, in order for the defendant to be found guilty. So it doesn't go on in perpetuity. Yes, I think so. And I think there's a lot of honest scientists out there, but I think it also is helpful to have other sources. I think that, just to kind of, I like to have more than one source, I guess is how I would put it. The justice system is very corrupt. I don't know that it's necessarily very corrupt. I just think people didn't really necessarily know exactly how it really functions, I think, until the information started coming out. And then now they're kind of perceiving like, whoa, this is really corrupt. And it's like, well, it kind of is how it's always been. And maybe it is corrupt, but that's how it's always been. And we change it, it gets better. And again, this idea of having these two huge trials with two women judges, again, shows you how much things are shifting and changing. And, I think that's interesting to see. So I'm thinking it's changing. It's just, oh my goodness, happy Friday. Yes. Oh my gosh. Yes. So happy. People are corrupt, not the law. I think the problem is too, though, sometimes people make the law. And, I know there's that saying, ignorance is no excuse of the law, but also ignorance is no excuse for the law either. So I think those really play hand in hand. And sometimes we got to kind of be careful of that too. Yeah, I don't know if we need to elect the head of the Justice Department. I think if that's an elected position, it really kind of takes on another connotation. It's interesting, and I think it needs to be part of a branch of the government. But because there's checks in places, we've got two other branches of the government that can keep that position in check. Just because it always doesn't make it right. Absolutely. Absolutely it doesn't. No, I'm just saying that, I think for a lot of us, it's not particularly surprising, is all. What are you feeling about the Supreme Court justices being a lifetime seat? Well, there's good and bad with that, with all of our federal judges. There's pros and cons with it. It's written in the Constitution, but at that time, you didn't really live that long, honestly. But, I I don't know. I think someone suggested the other day having something like a physicals like the president does. I mean, there needs to be some kind of boundaries placed for when judges are not able to decide for themselves, to make good decisions for themselves. What can we do? So, it's a fine line, but I think something should be put into place to kind of help the judges make good choices. And I look at it like all of our senior partners in a lot of our law firms, like they probably could have stepped down, maybe 10 years ago, but they keep going. And that's not necessarily a good thing. So that's just kind of, it's my random thoughts about it. It'd be good to have something in place, but yeah. Yeah, I think so. I'm not sure what would be the best to have in place, but I think something would be good. That would be a lot, Tosh. That would be a lot, but you're not wrong. You're not wrong. Do you think they should have ethics? Oh, absolutely, Suze. Absolutely they should. And I don't think they should be fighting it either. I think that's very distressing. And I did a full, and on my Two of You channel, I've got a live that I did going through all the different pieces of judicial ethics, as well as reading the letter that Chief Justice John Roberts wrote to Congress. And I think if you listen to that letter, you're like, well, wait a minute, what? What are you talking about? So it's frustrating, and I think it's disheartening. I'm a huge fan of the ethics. Everyone should have ethics all over the place, and accountability. Everybody should. Defined terms will turn them into election. Well, and that's so true, Law of the Wild. That's so true. And if you look at the states where some of the judges are elected and have to register as a certain party in order to be put onto a ticket, there's huge problems with that. There really are. So, I mean, I'm not sure what's better. It seems like something needs to be done, but I'm not sure elections would be the best way to go. Barr would take issue with SCOTUS well, yeah, and they do. But again, they're really at the top, and we're not allowed to really say disparaging or negative things about other sitting judges or other attorneys who are about our field. That's part of our ethics. But, I think we can critique to some degree. But I think for our Bar Association, they have suggested the Supreme Court set out some ethics. They have said that. All of our people have said that. But they're not doing it. Yes. Oh, the Magna Carta. Yes. Beautifully written document for its time. It was ahead of its time. Clarence Thomas, again, yes, model rules of professional conduct. Exactly. And I've spent a lot of time looking at those rules. I've got a copy of them just right next to me, actually. Very important. But I think Justice Thomas, just based off of his writings, honestly, over the last 10 years or so, you can kind of see his writing has kind of changed a little bit. And of course, his clerks are writing quite a bit, but, you kind of start to get that feeling of like, what? What are you saying? What are you talking about? And then that's when the red flags start going up. So I know there's a lot of ethical concerns, but I think there's a lot of practical concerns too that can sometimes, make their way in as well. And some people believe that, and some people do believe that. He makes the best arguments. Well, he certainly is pretty consistent with what he believes in with his arguments. I'm hesitant mainly because of the questions he asks during oral arguments and the way that he frames a lot of his most recent decisions, I guess is how I would put it. Just from an academic perspective, from my academic perspective, is how I look at it. The best lawyers use science. I think so too, but we don't understand science. I think that's a big issue. Yeah, I'm not trying to say I'm for or against Justice Thomas. I'm just saying, looking at their writing styles. Like right now, I would have to say Justice Brown Jackson, her writing style is probably my favorite. Probably Justice Barrett's, her style is probably my second favorite. So if you're just looking at it from a writing style perspective, is really where I'm coming at it with Justice Thomas. I'm not a huge fan. I'm not a huge fan of how he asks questions, of how he writes, what he's been writing, and especially lately. I'm not a huge fan of Gorsuch either. I mean, if you want to be poetic, fine, but it takes a lot of extra time. I guess is how I'm putting it. That's how I would look at it, I guess. How many judges are on the take? I don't know. Against the litany of substantive due process because it's unstable grounding. I think he's got legitimate arguments to back up what he's saying when it comes to substantive due process. I just don't like how he says it, is how I would put it. Not that he is saying it, but how he's saying it. I think we should add more. I don't know. No, I'm not sure that we need to add more, in my opinion. I think we have enough, even though they're like, oh, we've got a short pool, so if one person needs to step aside because of conflict of interest, then we're down one judge. I get it, but I'm not sure that we necessarily need more to that. Do you think some of them might be on the take? Honestly, in all honesty, I really don't know what on the take means. I mean, if they're about the benefits, the fringe benefits, I guess, or the gifts or the comps or whatever that you want to call it, I think there's a lot of things that go into that were bad practice by a lot of the justices, and not just these justices, but I think a lot of the justices in the past have had some issues. Can you give me an example of his writing that you don't like? Yeah, let me see. Let me see if I can grab. Sorry, I put my pen in my mouth. That's not helpful. Let me see if I can pull the case up that I was just reading through the other day. It's the one with the Canadian border case. Let me see if I can just pull it up. One moment, please. Egbert v. Boole, I guess, would be an example of a case I read where I'm like, what? What are you talking about? 10 moments. Yes. Oh, sure. Yeah, and again, I'm not sure that his decision was necessarily right or wrong. I just wasn't particularly a fan of how he went through and put his rationale together. So that's probably one of the biggest ones. The other one that I was reading too, would be, let me see. There was another one that was a restraining order case. I'm trying to remember the name of it. And that one had a lot to do with whether or not we had constitutional rights in a restraining order. And that particular piece, I just did not agree with his analysis whatsoever. I did not think he really fleshed out what he was saying in a way that made sense to me. I can't remember the name of the case. Was it maybe... I can't remember. But anyway, sorry. That's not very good. It's not a very good explanation. Oh, all right. Back. Here I am. I'm back. Sorry about that. Yes. Yeah, Egbert's. Not a huge fan of that. Love your lives. Oh, thank you, Elise. Thank you. Is there a new case number for today's filing? No, it's the same case number, but there's the newest document number is number 28. But this is the case number right here for that case. Presiding judges are indoctrinated. I don't think so. I mean, I guess for my understanding of indoctrinated, I mean, they're taught about the law. We all kind of have a certain way that we're taught, I suppose. He's still a Supreme Court judge. Oh, absolutely, Harry. Absolutely. He is a Supreme Court judge. Absolutely. And some of his opinions, I think, have been very well written. And, I feel like I was very lucky when I had an opportunity to sit down and chat with him. I think he's a fascinating person. On the take for money favors bribes. I don't believe that. No, I can say that strongly. I do not believe that at all. His dissent in the water rights case. Hold on here. I didn't quite. Oh my gosh, it was fire. Oh, you're so right. It was fire, but it was like really long-winded fire. And I can appreciate that again if I'm reading like a poem, a very long-winded, beautifully written poem. But sometimes it's like, look, dude, get to the point. I guess is what I would say with that. Too many pieces. Well, I mean, here, right off the top of my head, I mean, I've got like thousands of cases in my head right now. I've got to kind of look them up if you want. I posted 4 cases, I think, just today. I have over 350 cases posted to my TikTok account. So that's just the best I can think of off the top of my head. Barrett is paid for. I don't think so. I don't think Barrett's paid for. I think Barrett still has yet to prove herself one way or the other. I'm undecided at the moment. I may not like the process that has been gone through over the last few years regarding Supreme Court justices. I'm not sure that the protocol was followed properly, but now that the justices are in there, I have to assess them individually on their merits. And so I'm undecided about most of the new justices, except for Justice Gorsuch, because he is so long-winded, although, that's got its place. No offense. Oh, no, there's none of that here. We don't do any of that here. No, thank you. Nope. Do I need to type in document 28? No, what you would do is you'll go to the docket and then scroll to the very bottom. And document 28 is the last document that was filed. Oh, absolutely. Yeah, I know, right? Barrett and the chief just tossed an order on the yeah, I have not I've not read that one yet. There's been a lot that's been out about it. Oh, that's okay. No worries, Mads. You're doing fantastic. I've got kind of a little bit of a partner in crime here with me to kind of back everything up. So no worries. No, not at all. You're doing great. You're doing fantastic. I should send you a cake. I'll make you a cake. I'll send it to you. You put it in your freezer. Did you read Alito's Dobbs opinion? It's straight up nuts. I have. I need to spend more time on it. The thing about Dobbs is a quick side note, and I won't go too long because I'll do a whole live on it. But the thing about Dobbs is that he took it as an opportunity to really get out what he really wanted to say in the Casey case. But since he was the only dissenting judge in that case, he was kind of kiboshed. And so he was like, oh, Dobbs, I've got another chance. And so I feel like he had been holding it in until he had this opportunity. And then it just all kind of came out in Dobbs, which of course he's going into the Ninth Amendment issues and Glucksberg and, the right to unalive and those kinds of issues. So he took a completely different perspective on it compared to how we would normally think about it. But that's the same view he took when he was the dissenting opinion on the Casey case back in the 90s. So it's not that surprising. Oh, you love strawberry cakes. Okay, good. Oh, good. O'Connor surprised everyone in Casey. Yes. And I think it was interesting. I'm not saying I was for or against Casey. I'm just saying that I can see where Alito was coming from in Dobbs. You really can live stream these stuff on the... Some things, I'm pretty careful about what I say. I know the guidelines and I'm pretty careful. So what about unenumerated rights? Well, that's really the trick of it, isn't it? That's the trick. What those unenumerated or non-specified penumbra rights are. And before it had been argued so heavily under really the 4th Amendment, but primarily as a fundamental right under the 14th Amendment, which was what Roe was all about. But then you pull that 9th Amendment in and apply it the way that Alito did, and he took it down another road. Oh, thank you. Oh, Jilly Bean. Thank you. Oh, Pillsbury. Yes. I think that abortion really needs to come up as an equal protection issue. Yeah, I think privacy was tough, but I think the Roe court kind of did the best with what they had to work with at the time. But it really is an equal protection question, which had already been dealt with, honestly, in the sterilization cases, in my opinion. But there had been questions about whether or not that was appropriate or if it should be more of a due process question. So, yes, I could go on for days, but I won't But I will be doing a live just on Dobbs in those set of cases. Yeah, I agree. Absolutely. It'll be interesting, and I am getting ready to do a live on that. So I'm hoping to kind of get to that next week. It's on my list. We will see. Oh, today's filing was the protective order. They had a hearing on going through what the government had wanted, what the defendant had wanted, and then she came out with her kind of a mashup, if you will, of both sides in setting out what was going to be the documents that were protected, what needed to be written on them, how they needed to be modified if they want to be modified, and so on. So I think she did a pretty good job, in my opinion. Oh, thank you. Thank you very much. Thanks. Oh, I got this so long ago, I can't even remember. I remember, the only thing I remember was the color was a cognac. And so I was like, I'll take that. I'll just have that. Like a bird after something sparkly. I was all about it. I'm simple in that way. Oh, the ruby. Yes, that's one of my favorites too. Yeah, definitely. Not about stopping him from talking about it's really goes into the kind of evidence that he's allowed to talk about. So anything that's already public or that he already had access to, he can talk about. But if it's new stuff created essentially by the government or because of the government, those kinds of things are not allowed to be shared. Oh, the sapphire one. Yes, I've got that one too. I'll have to swap them out. Wasn't it illegal that the January 6th deleted? No, I'm not sure. Doug, interesting, because I think you're like maybe the 6th or 7th person that's asked that. Is there some kind of a story going around about evidence being deleted? Yeah, what's the source for that? Because I've seen several people now that have asked about that. There must have been somebody reporting that had happened, to have so many people. They must have seen the same story. But no, that's not happened. Think he will get a position where his posts have to be approved first? Maybe. I mean, I think his attorney could be in some trouble at this point. Yep. I can see all of the evidence. Yeah, I mean, and that January 6th report is, not holding much back. It's pretty clear about what's going on. Yeah, I'm just wondering if there was a particular story, a conspiracy theory. Okay. Sometimes I wonder where the sources are, because the questions seem to be like almost identical. Oh yeah, Suze, it was huge. It was enormous. I mean, there's a lot of information that is available for the public. I mean, that for anyone that has a hard time sleeping. Jesse Waters. Interesting. I'm going to put that in and do a little search on that later. I have no idea who that is. I really don't pay attention to this kind of stuff. But I find it absolutely fascinating when people start asking the very same words. Anytime, we're questioning someone on the stand and we've got two witnesses that are saying the exact same thing, it's always a little weird. You're always like, wait a minute, because it typically suggests that there's coaching involved, and that's one of the strategies that we look for. So when that happens, I'm always like, oh, interesting. I wonder who's been coaching somebody out there. So yes, I've got, I've been very lucky. I've gathered some fun little gems over the years, just for fun. That was one of my extra special treats to myself. Typically, usually when I had a really bad day, or if I had some tough things going on, I'm like, I'll just go to the jewelry store, see what's going on. Or go look at some antique shops. Why not, We all have our different ways of coping. Mine was jewelry. It's a bit of an expensive coping mechanism. But, okay, interesting. Yes. Yeah. Yeah, shopping therapy. Yes. Retail therapy. Yes. And it would have been better if it had been something else like shoes, I'm sure. Something more practical. But that was kind of it. And if I had a bad day, I would get home and my my significant other would look at my jewelry box and he'd be like, okay then. Oh, this is my Barbie nail polish. Had to get the pink out to go see Barbie this afternoon, so it was fun. Fishing tackle. See, that's useful. That's a useful, wonderful thing to collect that you can really get some good time out of it. Now, fishing, that's an exceptional way to help with stress. I love that. Yes, yeah. I was able to go see that this afternoon. When I worked, one of the first law firms I ever worked at, we had the defense attorney that I worked for would try to get away on Friday afternoons and go to a matinee, and he said it always helped him. So I kind of have done that as kind of a tip of my hat to him over the years. So yeah, I did like it. I thought it was pretty good. I mean, it's pretty hokey in some spots, but the parts about the all Barbie Supreme Court was amazing. Oh, there were a few legal arguments that were actually set out where I was like, ouch, if anyone really knows what that means, ouch. So I thought that was pretty fun. I enjoyed that. Love fishing, but the fish know I'm vegetarian. So, I think that's okay though. I think, that's still, a worthwhile goal to go for the fish and then just be like, hey, I'm just here visiting. I'm not here to harm anybody. There's a person called Decoding Fox News who exposes the disinformation and misinformation. Oh, really? Oh, I had no idea. I learned so much from all of you. I have lists whenever I leave my live. I'm like, oh, I have so many things I need to look up that everyone has told me about. Okay, I've got that. Ooh, interesting. I've got that tabbed. I'll have to take a look at that. They do excellent work. Okay, good to know. Good to know. Your significant other's seeing it now. I'll wait to see if she tells me about the Barbie. Yes, no, it's good. It's funny. I think it's funny. I mean, it's funny, but like kind of a painful, like, ooh, that's so true. But then it's also funny, so it's got, it's good and bad. Fox has done so much damage. I think, I don't know. Sometimes when I saw Anchorman for the first time, Ron Burgundy, and they were following the car and he was making it such a huge event that they were just chasing this car. That was the moment where I was like, this is where things took a turn in our society, in my opinion, when we had those moments where rather than investigating, we just were trying to get everything all kind of hopped up and exciting. And so rather than really taking a look at what was going on. So, that kind of moment was like, ouch, it was a bit cringe. Yeah, I think so. I think that was pretty true. That was pretty true. If it bleeds, it leads. Yes, exactly. Exactly. And, I understand. We all have short attention spans. We all are like, what's going on? But for me, I'm like, I see enough of that in real life. I'm not wanting to see it when I get home, I guess. When the FCC decided cable news did not have to stand by. Yes, that was a big moment, wasn't it? That was really a turning point. Yeah, we had a few of those. Hola. Okay, has changed. Really quite efficient. Really? Well, that's interesting. That's very interesting. Okay. I may look into that. I didn't know much about him before other than kind of little blurbs. I have very limited places that I look when it comes to what's going on in the world. So I'm pretty unknowledgeable about that. So I'll have to take a look in that. Evening news was a must. Yes, absolutely. I think that's good. It's funny because when my mother, oh my gosh, she always said that the news was unreliable because people were unreliable and they made stuff up. And I remember growing up that way, and I'm like, well, that's interesting. And then when I got older, I found out that her parents were involved in a lawsuit and there was a mean reporter, and so she had this bias. And I'm like, wait a minute, now hold on. This whole time, my whole life, I thought news reporters weren't trustworthy, but it's really about your own bias. So now I'm like, gotta question everything. But I think it's always good to kind of, I know, right? I mean, don't get me wrong, I love her to bits, but I'm still, sometimes I give her the eye. I'm like, I'm giving you the stink eye right now because of that whole news thing my entire life. I do try to, make sure I've got, I've got a good perspective from a couple of different views. Walter Cronkite time. Oh, true. I think so. I think some of the greats, the ones that really started the industry and made it what it started as was they're fantastic. Absolutely. It's just a little bit different, and I think it's definitely kind of that Ron Burgundy syndrome that's kind of taken over. Dan Rather, I think he was good, although I think things kind of took a turn for him after the 2000 election. I think that was a pivotal point for him. But was there, who was it? Walter Cronkite, Dan Rather. There was another guy. He was just on the other day. Tom Brokaw is who I was thinking of. There were some good ones. Rachel Maddow, I catch her every once in a while on the TikTok, and I have to say, I like how she presents things. I do like how she just kind of backs up what she's saying with like facts. I can appreciate that. Peter Jennings, yes. Oh my gosh. Yes. Yes. Oh my gosh. Wow, we're going old school now. Those were the days. Those were the days. She's your favorite. Oh, excellent. Oh, Barbara Walters, yes. Oh, Moreau, of course. Classic. Classic. She does her research but is opinionated. Yeah, that's the one thing is she definitely has her view on things. And, sometimes for me, if you want to dabble, that's fine, but which I don't mind that as long as I know I'm dabbling. But I try to get kind of all sides. But again, I can appreciate the depth of the research that goes into what she's talking about. I feel that way about John Oliver. Quite frankly, I think he's one of the best out there when it comes to in-depth reporting on a huge issue. Some of his exposés are like better than Frontline. I mean, they're a bit crude, but he does an amazing job. And I would back up John Oliver any day of the week. Hands down, all about that. Oh, he wanted back. Yes, he was amazing. He was amazing. You always avoid my question. No, it's just a lot of things kind of come through at the same time, so I try to catch as much as I can. You might have to ask again. Richard Engel. Oh, okay. Tucker Carlson. Yeah, I mean, I might have to take a look and see what's going on with Tucker. A special counsel should be outside of the government. Well, they are. I mean, they're pretty much as outside as they can get. But we still have to have certain rules in order to appoint them, and it involves the government. So we do try. I'd love to hear his take on this. Yes, yeah, I think it would be interesting. He's always got a very, I think, unique perspective. He's able to kind of put it together. Lawrence, okay, sure, yeah. I think so. Is this the first time a president lies over 4,000 times or a president cheats were? Yeah, I mean, I think again, I think I made a post about this. Judge Glass put it best. In this day and age, everything is recorded. Everything. From videotapes to audios to texts, everything is recorded. So our evidence is a little bit different than it used to be. Yeah, I mean, it's definitely, it's the AG's discretion when a special counsel gets called in. Yes, but that was decided by Congress. Congress wrote the statute that designated the AG to be the one to do that. So it was actually decided by Congress. So it's because that's how the law was written. It's not because the AG is like, I'll do it. That's just how they changed the language in the statute. And the language got changed, not that long ago. I mean, of course, we had what was going on in the 90s, but it was shortly after that where we had some of that federal statute expire, and so they rewrote it and they put into place that it would be the AG's office. It is. It's a lot easier to get a hold of and easier to share. Absolutely. And people don't really think about it too. We just don't have the same perspective on privacy that we used to have when we're looking at. I think a lot of attorneys do, but I think regular people just don't. That's a lie. Which one's a lie? You'll have to be more specific based off of the comments tonight. There have been a lot of questions about lies, so you'll have to be more specific. But I think a lot of people just don't necessarily pay attention. I remember, I mean, every time I go into a grocery store, I always look for the security cameras because I'm always making sure that if there's one looking down at the keypad when I type in my PIN number, I make sure to cover it. But if there isn't one up there, there's not. But every single store I go into, I look for a camera. And so if someone's with me, they're like, what are you looking for? I'm like, looking for the camera. They're like, so what? Who cares? I'm like, what? You don't look for a camera? Like, I thought so. Oh, do we have a troll? Are you being a Oh, open the book and read it. Oh, I have. I most certainly have. I actually have a huge copy of it up on my wall. All right. Well, let's not be rude. I'm going to have to give my signal over here. Signaling. I don't like to spend too much time. Yeah, I don't like to take too much time away from other people with good questions. So, yep. Yeah, sometimes it happens. I mean, we're talking about pretty controversial issues, but I think it's good to discuss things back and forth, but hostility alone, I don't think serves any purpose necessarily. I just saw the original last week. Couldn't look for a treasure map on the back though. Oh, that's right. You went to DC. How was it? How was the weather? It looked like it was super hot there. Do you look more now for cameras? I do look more now for cameras than I used to. Good for, I mean, I'm not trying to say be paranoid, but there's some safety concerns. And after you see enough people who have had, it was hot. Yeah, I thought so. But when you've seen enough people being charged with, stealing identities and various things, it's like, oh, I better be more careful. I really appreciate you educating us from the book and not about, well, right. Yeah, you can, there's plenty of places to go and look for conspiracies, it's just not here. I just try to look at the facts as best as I can. Oh, it's humid there too. Yikes. Military training. Well, I actually was signed up. I was supposed to go into the Army. All my family went into the Army, but I was too short to do the job I wanted to do. And so I was like, I guess I'll go to college instead. So, and I did, and I was okay with that. My family, they were like, fine, but, oh, that's a good idea, Mike. That's an excellent idea. Excellent. Yeah, I think it's good. Oh, okay. Yeah, I got you, Hawk. I got you. Love to hear it. It's a shame that our Constitution is often ignored and abused. It's true. I think it could have been better explained. Could have been a JAG. True. And I've met a lot of JAG people since then. And, I'm okay with the path I've taken. Oh, way better than you. Oh, that's so nice of you to say. Oh, what kind of law do you practice? A little bit of everything. I really am more client-oriented than subject-oriented, as long as I'm educated in the matter, or that I feel educated enough. So they would have paid for law school. I know, Hawk. That was one of the reasons I was looking at it. And my brother had been in the Army also. I mean, my whole family was. And so I was like, okay, I was getting ready to go, but I was like, I just couldn't do it. But yeah, looking back now, it would have been nice. No, I have my own firm. I'm a solo practitioner in my own firm. As we call it, I've put up my own shingle. So, and I'm happy that way. It took a really long time. To be in a position where I could hang up my own shingle. And now I am so thankful for it. Do I ever handle ADA type stuff? I have in the past. I don't really, these days, I don't have any going on right now, but I have in the past. Thank you so much for educating us. It costs hundreds of dollars for what Oh, you're welcome. Yes, I, absolutely. I have and continue to teach when I can, and I just found this to be such a fun way to interact with other people and share my knowledge. I don't think, I should be the way I put it is like, I'm not here to bogart the law. I'm here to kind of share just as long as people are wanting to learn. So yeah, I can work at my own pace, which has been really nice. I would appreciate that. If I was an animal, what animal would I be? Wow, that's a really good question. I don't know because I'm torn. Like part of me wants to be a hippo, but I also am like not a big fan of hippos because I think they're kind of mean. Like they eat people, like they eat a lot of people, but yet they're like vegetarians. So they don't eat people for like the meat. They eat it each because they're mean. I probably disclosed too much, but panther. That could be. Oh, an orca. Yes, yes, an orca. Sure. Oh, I like that. That's a nice one. Oh, a giraffe. Yes. 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 I mean, I have a love-hate relationship with hippos. They will kill anything. They will. And like part of me kind of respects that. Oh, the lawyer king. Oh, that's funny. Oh, a tiger. Yes. Jaguar. Oh, yes, yes. You guys all have these really classy answers, and I'm like, oh, a hippo. Doo-doo-doo. Oh, dolphin. Oh, nice. Oh, a pink dolphin. That would be fun. Falcon. Yes. Oh my gosh, that would be fantastic. Oh, that would be great. Yes, all excellent. Oh, a horse. Yes. Those are all such great answers. Can the state be filed as a plaintiff in a criminal case? Well, technically, there's no plaintiff in a criminal case. We have the defendant, and then we have the government. So we don't really refer to them as a plaintiff. Like if we're in civil court, we have a plaintiff and a respondent, or a petitioner and a respondent. But I'm not sure that we really call them a plaintiff, I guess. Hold on, let me think about this for a minute. I'm getting your question tangled up. So you're saying, can you name the state as the plaintiff? Well, the state, the government is the one bringing the criminal action. So I guess that's a yes. How's that? I went around, I said no, then I said maybe, then I said yes. So that's my answer. That's a terrible answer. Sorry about that. It is getting a bit late for me at this point. But yeah, the government is the one bringing the suit because it's the people. Yes, thank you. Thank you, Law of the Wild. I appreciate that. Oh, yes. It's a little hot in here. It's getting a little bit late. I'm getting a little bit loco. I'm focused very strongly on this hippo energy right now. But yes, thank you. We need to protect this thing. Oh my goodness. Oh, you're too kind. You're too kind, everybody. I'm thankful for that. Oh my goodness gracious. Yes. Oh, thank you. That's so nice of you. Oh my gosh. So yes, I am a real attorney. I am. What's a friend of the court? We call that amicus curiae or amici, and that just means friend of the court is someone who is sending in a brief typically in order to kind of help the court understand what's going on in a particular case. So that's usually what we would say would be an amicus curiae or amicus. Were you ever a prosecutor? Yes, I was a prosecutor for several years. And then defense work as well. Thank you for all you've done. I look forward to hearing from you. Oh, thank you so much. But I'm going to start my schedule of Mondays and Thursdays next week. So I'll be on break here for a few days. I've got to kind of dig out my desk so I can see my desk again. Let's see. Can you sue someone for attempting to steal or no actually stealing it, just attempted? So, I'm not sure about attempt. I'm trying to think because if we're suing, it's a conversion and that's when you take it and you change it. But I'm not sure. I think my brain is starting to not function properly. Did you see the video of the squirrel faking his death with a broomstick? Oh my goodness. Oh my gosh. Oh, okay. I'm writing that. Hold on. Let me type that in here. Squirrel, death scene, broomstick. All right. I pulled it up. I'll have to look at it later. Oh my goodness. What are the basic elements to prosecute? Well, every crime has its elements set out within the code. So whatever the code sets out, those are the elements that you're looking for. It's hilarious. Okay. Yeah. Oh, yes. You have a great night too, Serena. Thanks for coming. Thank you for coming. I really appreciate that. It really is a fun list I'm putting together. I'm quite excited about it, actually. I'm very excited. Oh, goodness. Yes, good night, good night. What kind of a prosecutor were you? City. I started in a very, very small community, a very small community where you couldn't walk to the grocery store without someone, trying to spit on you. But I did move into more of a mid-size level jurisdiction, and that was where I finished my time there. So, what's the strangest case you ever had to prosecute? Well, I had a couple. I would say probably, well, I was defense counsel. I was defense counsel on a case where a person had hit another person over the head with a 2-liter soda bottle, and it was some kind of question about whether or not it was a weapon. And I'm like, I don't think that's defined as a weapon under the law. Oh, but there's that. And then I think for prosecuting, we had one, and I call it the cookie caper, where someone was stealing like the Little Debbie snacks from the grocery store, and the grocery store was so mad about it that they wanted to prosecute. And I'm just like, all right, so all these years of law school and undergrad and all of the student loan debt so that I can bring, the cookie person to justice. And it was this little old woman who kept stealing cookies. I think that was probably the moment where I'm like, I'm asking my boss, I'm like, you sure we're doing this? He's like, we are doing this. I'm like, oh, I don't know that I'm like working for other people. Yeah, it was. It was the little. Oh, yeah, that was a tough moment. That was a tough moment for me where I'm like, what am I doing now? What is this? Like, I'll give you the money. Oh, let's make a schedule. Yes. So I have put on my profile page on my TikTok, I've put Mondays and Thursdays, and I'll be doing 6 p.m. Central Time. So with my work schedule and with what I've got going on in my world, those I think are the best dates. Now the topics may change depending on what's going on, but those will be the dates and the times. So Mondays, Thursdays, 6 o'clock Central Time will be the best. You sent Grandma to jail? No, of course not. She didn't go to jail. She had to pay a fine. It was a minimum fine, and she had to pay back the Little Debbie snacks. They asked for the worst case. That was the worst case. Truly, it really was. It really was the worst one. Had a client okay, on a very minor misdemeanor that the prosecutor just won't let it go. Yeah, sometimes I tell you, sometimes we just don't have a choice as the prosecutor. We answer to somebody else. And if our boss is like, you're going to do this, you have to do it. I mean, I remember I went full on a $10 campground ticket, and I just looked at my boss like, I'm not sure this is going to work out for me here in this office. Sometimes you just gotta, you gotta do what you gotta do. Oh, that's funny. Yes, it can be difficult, but sometimes you just gotta do what you gotta do. Spending way more time and resources on charging this. They won't even plea. Sometimes some of them will just get a wild hair and will just go on. I remember I had a very good friend who's still a prosecutor, and I won't name any names. His name is Mike. But he, in one of the cases that he was working on, he had a woman. It was a domestic case, and her domestic partner had thrown a package of hot dogs in her general direction. Now, I'm not trying to make light of anything, but his entire argument, and I was representing defense counsel, or I was the defense counsel in the situation, helping on that side, and his whole argument was, well, the hot dogs were frozen, and that, could be deadly. I'm like, you raise a good point, but I mean, I've got 150 other cases I'm working on. How much time and energy do we want to put into this? So, how many trials have I done? I think I counted it up, and I had hit probably, I think the number I'd come up with, I think it was around 500 trials as a prosecutor. And so that doesn't include what I did on my own. But It was not in a hallway. It was in the living room. And I'm not trying to, belittle the situation. You shouldn't throw objects at other people. That's not good. It's wrong. But I'm just saying, I've got 150 other cases on my desk. We got to prioritize, is what I'm trying to say with that. It's a lot. Yeah, I've had a lot of trial work. More trial work than most people. Attorneys really don't spend that much time in court, honestly. It's our prosecutors and defense counsel. That's where a lot of our trial work goes into. So, yes, I had been going through the indictments previously in previous posts, but tonight I was just doing the protective order that was put out today. So, yes, no, I got you. No, I'm totally with you. I totally got that. No, and I said that to my friend too. I'm like, were they in the hallway? That was a legitimate question I asked. And he's like, no, they're in the living room. I'm like, okay, well, did I mention the 150 other cases I have that I'm working on? Not to, belittle anything. But sometimes prosecutors can just go after it. Although I have to admit, when I was a prosecutor, I had a defense counsel come to me years and years later and ask me about a case. There was a case involving a stolen bicycle at the university in my town. And apparently I had just totally gone after his client for the stolen bicycle. And I wanted like maximum penalties. And I don't even remember this. I'd done so many trials. I'd done so many cases. And he said, yeah, you wanted maximum. But, the bike didn't work. It didn't have a seat. It didn't have handlebars. But you wanted full because it was technically a bicycle. I'm like, what? I'm sorry. I don't even remember. I don't remember those things. Are you getting docs from Pacer? I can get them, but I don't for when I'm doing my TikToks. I try to make sure that whatever I show on my TikTok, everybody can get access to easily online. So there are Pacer options, but everything I show is all public and available online. Yes, I did watch Daryl Brooks. I mean, I kind of watched in between my hands. I had to kind of cover my eyes sometimes. There were moments. Did I have ambitions to be a judge? I did in the beginning until I did enough cases where I'm like, nope, that's not for me. That's just not for me. Thank you, though. I think that the jurisdiction where the crime is committed is the jurisdiction where we try the case. And that's just how our process works. I think if there wasn't the ability to have a fair trial, then they would have been moved. But I think, that's how it's written. Wherever the crime has been done, that's where you go, so long as you can get a fair trial. And if the judge felt that they couldn't have, they would have moved them. So that's really how I view it. Yes, well, you could try, but getting a kid's bike back is a noble case. I think it was just some silly college kids that were just taking this bike around. But the funny thing was I had no memory of it. But this poor defense counsel was like, you were so mean. I'm like, oh, I probably was. Sorry. Oh, goodness. Those were the days. How's preparing for trial defense between prosecutor and being defense? I think, if you're defense counsel, not all of your cases are always going to go to trial. And you've probably got a bunch of different kinds of cases going on. But when you're a prosecutor, you've got, 200, 300 open cases. And at any time, you could have 6, 7 pretrial conferences constantly, and you're constantly preparing for trial. So I think it's just a matter of quantity when you're a prosecutor. And so you just get into the routine of it. Yeah, no seat or handlebars. They just carted it around. It was part of some fraternity prank. It was just, it was just a joke. And I was taking it so seriously. It's tough. It's tough. You got to be careful with your time on it. Oh my gosh. Yeah. I was saying he was looking pretty good on the news compared to, I don't even remember a lot of my time. When I'm prepping for trial, that's your whole world. People have to throw sandwiches at you because you forget you're supposed to eat and drink. It's tough. But anyway, everybody, this has been such a blast, but I'm taking a look here at the time and I should probably let you all go. It's been a few hours now. I'm trying to keep these short, but I just can't. Everyone has got such great comments and interesting questions. So, but yes, of course, you are most welcome. I will return. I will be coming back on Mondays and Thursdays, 6 p.m. Central Time, and I will announce the topics when we get closer. I'm really hoping to do the Dobbs and Rowe case pretty soon, so that's definitely at the top of my chart. So, yes, oh, you're welcome, of course. But if anything really big comes down from either of these cases, I will kind of pop on and let everybody know. So, keep everybody posted. But yes, thank you. Thank you all for coming and joining and asking so many fun questions and being interested. And again, I do have a Tube of You channel, and I will post this live on it in a couple of hours. It takes a little time for it to all upload and stuff, but we'll have it so you can take a listen, fast forward, and catch up on anything that you might have missed. So that's okay. I'll be back. I'll be back on Monday, and we'll have something really fun and interesting to talk about. Yes. Oh, yes. I'm so glad you could all join me. It's been fantastic. Wonderful chatting with all of you. Yes, and thank you too, Desert Skies. So good to see you. So I will hop off and go and have a relaxing, yes, good night, nerds. Yes, and thank you for modding. I'm so thankful. You did a fantastic job. So, oh, thank you, April. Yes, everyone have a fantastic weekend. Thank you again for joining me, and I will see you all on Monday. Yes, you bet. Take care, everyone.